Commonwealth versus Taylor Chambers. Come around. Are you Taylor Chambers?
Yes, sir.
You were born in 2001.
Yes, sir.
Last four digits, social security number 6405.
Yes, sir.
It says it's a pretrial diversion revocation.
Your Honor, Mr. Poindexter does, I think we just walked it over.
Of course. Did somebody find Mr. Poindexter right there? Mr. Poindexter, you represent Taylor Chambers.
I do, Your Honor.
Hey, Mr. Stockton, you want to proceed?
Yes, Your Honor. I'll leave Mr. Burke. Yes. We'll stipulate.
Oh, stipulate.
We'll stipulate the violations.
Okay.
What do you have?
It's a 5-year sentence on theft of unlawful taking, Your Honor, and she was placed in the specialty court program. And the violations were that after she completed rehab, she had 2 positive drug tests.
Okay, well, I will void her pretrial diversion and order a pre-sentence investigation report. She'll be sentenced on March 19th.
Did not. Your Honor, okay. I didn't realize that was the motion day. I've got a mediation, but I'll move mediation.
Okay, thank you. Kenneth Alexander. When's your negotiation day?
March 8th at 1 o'clock.
Jay. Are you Kenneth Alexander?
Yes.
You born in 1964?
Yes.
Last four digits of your social security number 6237.
Yes.
We're here today on a pretrial conference.
Morning, Your Honor. We're close. I received an offer a couple of days ago. I know Mr. Stockton had some difficulty reaching the victim in this case. We could just get that March 8th negotiation. I think we may have a
The
resolution.
victim actually has been declared incompetent. She's got a legal guardian through the cabinet. I was able to reach, talk to her guardian about this case, and I made an offer to Mr. Pennington a day or two ago. So if we could have one more
What is
negotiation.
the offer?
It was actually a wanton endangerment, diversion, no contact.
Is there any reason why that can't be wrapped up today?
Judge, we can recall it. I can.
Do what?
I can discuss it with my client. We can.
Yeah, I mean, it's pretrial diversion. You can get it over with today and he knows what's going on. Once you take an opportunity to talk to him about that.
Certainly, Judge, if we can recall this at the end of the docket before we go to the.
Or whenever you get a chance to talk to him. If you get a chance to talk to him before then, bring him back up. Okay?
Yes, Your Honor.
Timothy Alexander. Are you Timothy Alexander?
Sir.
Was born in 1982. Last four digits, social security number 5227. Okay, what's the Commonwealth have here?
Well, we have our motions to, I've got 2 out-of-state witnesses I have to get from Nashville. To the
Yeah.
medics. I need that domesticated.
And
3, I'm sorry, there was a late file.
Can you have the motion to dismiss?
Yes, Your Honor. Based on the Castle document.
Yeah.
Oh, that's.
Well, I don't have any facts in front of me.
Yeah, and if we need to have a hearing, I guess I've made a mistake because I thought this was taken care of last meeting. I know Mr. Hunley was talking to Mr. Haywood, and I thought the case was settled. So I didn't send Mr. Haywood here today to put on any evidence. I mean, we can have a hearing whenever the court desires, but I'm not prepared today to.
Right, yeah. I figured that the court would have a separate date.
You're gonna have to speak up a little bit.
I'm sorry.
Speak up a little bit.
Yes, Your
In
Honor.
the microphone.
I expected us to do the hearing on a separate date than your regular motion day. So if we could pick a day between now and the trial.
When is the trial?
The 18th of March. And I don't know if that's realistic with the doctors in Nashville or not, but I want to attempt to make that date.
You said you thought you had the case settled.
Yes, and in fact, I was informed by Mr. Poindexter, I thought, we both, I think, had thought we had it settled. Then the last time we were here to draw up the paperwork, Mr. Alexander said he wanted to go try. And I want to accommodate him, but I just don't know if I can have my doctors up here the 18th.
Who is the complaining witness that you?
He's a gentleman named James Haywood. He works at Foothills. I don't know what he's doing now since they closed that over there. He's unemployed or what, but he's local. I can get him in about any time.
Well, let's schedule it for March 7th over in Clinton County.
Could we do it another day, Judge? Because when I was out with COVID, I've had to reschedule a doctor's appointment. I'm gonna have to leave probably by 12 on March the 7th.
I'm not available either that day, Your Honor.
Do what?
I'm not available either that day on the seventh.
Excuse me, I could, if we have to, I'll get.
Which was a morning of day. If
I've got mediation and stuff.
okay.
It's been rescheduled twice.
Understand.
Can we do it the 14th in Monroe County? In the afternoon?
That'll be fine.
Okay.
Schedule it for the 14th in Monroe County.
Okay.
And when you'll be able to give us notice within a week if the trial date's okay?
Yeah, I'll, once I get these subpoenas set down next week, I'm gonna call and make sure I've got somebody come up here to testify on that.
Okay.
Will this be at 1 p.m., Your Honor?
That's fine with me, so that
Okay.
it is the court.
That'll be fine.
Okay.
Maybe I can sit about it. That's what I like to laugh.
Okay. And for my client, that'll be in Monroe County. That's.
Come up versus Dwayne Allen. Since you active warrant out. He went to rehab yesterday, so he won't be here.
It's good to know.
There's an active warrant out for him. Find out where he is and bring him in. She say where he went to rehab? Do what?
Here, since she was running that one.
Yeah.
Adam, who did you say, she, who?
Amy Huddleston, Amy Huddleston.
Came in, said he went to rehab and ran out before she had any questions. And like a drive-by. Well, versus Richard Armstrong. Richard Armstrong. Are you Richard Armstrong?
Yes, sir.
You're here on 23-0080. Were you born in 2000?
Yes, sir.
Last four digits, social security number 7619.
Yeah.
Is that right?
Yes, sir.
Okay. We're on a pre-trial conference. What do we have?
Judge, we have a pre-trial verdict resolution.
A motion's been tendered, sir, that says you wish to enter a plea today. Is that correct? Okay, yeah. Are you interested in doing this? Because if you do, you're gonna have to answer. You have to speak up. You have a voice activated microphone. Unless you speak up, the camera's not on you, okay?
Yes, sir.
Okay. A motion's been tendered that says that you wish to enter a plea today. Is that correct?
Yes, sir.
Speak up.
Yes, sir.
Okay, are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes, Your Honor.
Are you the same person named in the indictment that I just read the number of?
Yes, Your Honor.
That's what.
Yes.
He's got to answer.
Yes, Your Honor.
Okay. It's part of the competency thing, you know. Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, Your Honor.
You can just say yes if you want to, real loud. Let me hear you say yes, real loud.
Yes.
Okay. Have you reviewed the evidence the Commonwealth has against you? You feel like you're fully informed about your case?
I'm sorry, Your Honor, I didn't catch that.
Have you reviewed the evidence that the Commonwealth has against you and do you believe that you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm gonna go down through the rights to the end. I'm gonna ask you if you understand it. You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, your right to be represented by counsel at your jury trial. Your right to confront and cross-examine all witnesses called to testify against you. Your right to produce evidence, right to call witnesses in your behalf and have process issued, compel their attendance. You have a right to appeal this matter to higher court if you lose, and a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. You understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
Okay. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by the law. I don't have to accept the recommendation. And then I don't accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea. Now, I'm going to ask you some qualifying questions here. Have you previously been diverted in the last 5 years? Okay. Have you had any felonies in the past 10 years, or are you currently on probation?
No, Your Honor.
Okay. Do you understand if you fully complete the diversion program, the charges will be dismissed, pretrial diverted, and you can have your record expunged? You understand that?
Yes, Your Honor.
You understand if you don't complete the diversion program, you'll be brought back to court to schedule a sentencing hearing, and then you'll be a convicted felon. And any convictions in the future could be used against you. Do you understand that?
Yes, sir.
Okay, Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years, pre-trial diverted for 5 years. Diversion is to be supervised. Upon a plea of guilty to failure to maintain insurance, the defendant shall pay a fine of $500 plus court costs. The defendant agrees to be assessed by the social service clinician and will follow any recommendations. The defendant shall pay a fine and court costs at the discretion of the court, and the defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. Defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky and shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Is that what you agree to?
Yes, sir.
Are you pleading guilty of your own free will because you did commit the acts charged in the indictment?
Yes, sir.
Okay. Know your constitutional rights to explain to us still your desire to proceed and allow the court to fix your punishment. Is that your signature on the document?
Yes, sir.
I'll accept the agreement, sign the diversion order. What are the total court costs?
$695.
Yeah, was there a DUI in this?
So just his.
Insurance, Your Honor.
Insurance, okay, $695. You need some time to pay that?
Yes, sir.
Okay, I'll let you pay it $50 a month. First payment being done, due 30 days from today, okay? That was your signature on there, did you say?
Yes,
Okay. Okay, you need to meet with the probation and parole officer back there.
Thank you.
Bronny Bays. Commonwealth versus Bronny Bays. You are Bronny Bays, born in 1984, last 4 digits, Social Security 5442.
Yes, sir.
What do you have?
Commonwealth's ready to set a trial again.
Okay. You have Cromwell versus O'Donnell on 25th and 26th March. Are those hearings?
Those are hearings, Your Honor, and they're scheduled to go. I've got FBI agents coming in from the country.
Hey, Judge, this is a point of order. I anticipate this being a 2-day trial with a volume of documents. Make the court aware.
What is Commonwealth versus Tucker in Clinton County? What's that about?
That's a case with Mr. Frost saying
That another judge called me, just like I said, I'll have to give you a call back. I'm on the bench, okay? Thank you, no problem. What did you say?
that's probably a one-day trial and unlawful use of electronic device to procure sexual services of minor.
What day? Megan Lee,
She's on 17.
okay. I've got another date that was problematic, that's in there.
And Judge, while we're getting it, Dave, I just want to make sure, clarify, I know the Commonwealth had proffered at one time about seeking an indictment against another alleged co-conspirator.
Ain't no additional indictments.
Thank you.
That would have been done today.
You say Tucker was an electronic device?
Your Honor, there is, and I hadn't told Mr. Pennington this, Jason Warner is unavailable on the 15th of May on the Darian Riddle case. If you want him there, he was the one that made the tip. So I figured you want him as a witness. So you might want to set this May the 15th. And I'm going to have to get another trial date on Riddle probably. I was going to file a motion for next week in Clinton County.
How about May 14th and 15th?
But be fine with me on this case.
I just got error on my calendar because Monroe Circuit is not on that day, is it?
No, it's the 16th.
Okay. Judge, that worked for us.
No, no pretrial be necessary, is everything's finished?
Judge, we've tried. I don't think so.
Okay, Jason, that'll be it then. Commonwealth versus Jason Bowers. Commonwealth versus Jason Bowers, 22 CR 0082. Are you Jason Bowers?
Yes, sir.
Were you born in 1984, Mr. Bowers?
Yes, sir.
Last four digits, social security number 7956.
Yes, sir.
We're on a pretrial diversion revocation. What does the Commonwealth say?
Your Honor, Mr. Bowers has a 5-year sentence on wanton endangerment. On November the 1st of 2023, he received a DUI citation along with careless driving here in Cumberland County. Mr. Bowers admitted during the stop that he was operating under the influence. My understanding is if he stipulates the revocation, I was going to recommend that he go into the specialty court program here in Cumberland County.
And Judge, we're agreeable to that.
As far as his custody.
What was the wanton endangerment charge previously? About.
Shot a rifle 20 times across a public roadway in Happy Valley. Towards some residences.
And Judge, if I may, Mr. Bauer, I understand that being a while ago and a mistake. Mr. Bauer is currently a full-time student, has made amends for some of his questionable choices in the past.
Where is he, full-time student?
Were you going to go ahead?
That's NHU, Southern New Hampshire University, sir.
Online?
Yes, sir.
Well, you check most of the boxes that I don't like checked, firearm being used, firing a firearm around the residences, and then you get a pretrial diversion. And you get out drunk driving. I don't know.
Well, I assumed he'd be going into custody until he got into drug court. That's what I thought would happen.
I'll revoke his pretrial diversion. And then I'll take a look at, drug court at the sentencing, so. I have, or a pre-sentence investigation report, have sentencing, on, March 19th. Your custody, yes. Thomas Carson. Thomas Carson. Commonwealth versus Thomas Carson, 23 CR 00104. Are you Thomas Carson?
I am, Your Honor.
Your Honor, Your Honor, if I may, Mr.
Can you hear better now, Mr. Carson?
Yes, Your Honor.
Okay, were you born in 1952?
Yes, Your Honor.
Last four digits of your social security number, 5176.
They're working now.
Okay.
They're working now.
Turned off, Judge, sorry.
5176, last four digits social security number.
Yes, Your Honor.
Okay, we're here on a pretrial conference. What's the Commonwealth have to say?
Your Honor, I'd be ready to set a trial, but my understanding is Mr. Pennington's gonna file a bail motion about whether or not he can be placed behind the vehicle on the DUI.
I'm having a hard time hearing you. I don't know whether my
That's
ears.
probably me because I'm head
It
stopped
could
up.
be both of us,
And Your Honor, I'll take the lead. I'm going to file a motion to be heard at the next rule day. Depending on the resolution of that motion will dictate the posture of this case.
What would you care to
Certainly, Judge. It's
enlighten me as what that, all comprehensive motion might be?
not very comprehensive, all, Judge. We'll be filing a motion regarding the operation and control of the motor vehicle regarding to the DUI charge. Doesn't have anything to do with the wanton endangerment charge, which may likely be set for trial unless Mr. Stockton can speak with the victim about a different resolution.
Give me some facts about it.
This is a case where Mr. Carson allegedly drove in the victim's driveway. He was intoxicated, according to the victim. Then he went back. We're talking about nighttime hours.
Yeah.
And he went back to his house. According to the victim, he discharged a gun at his house. Victim, I think, saw the flash, couldn't tell which direction the bullet was going, from my recollection, talking with the victim. So that's the facts of this case.
Which gets at the crux of the bail motion on file. This
Are you
alleged
saying
victim,
are you saying the bail motion?
that's operation control of the motor vehicle
Yeah.
regarding the DUI.
Yeah.
Now, when we get to one endangerment, Judge, even that proffer of the facts may meet one second, but does not rise to level one first, but that's
Of course,
first.
I don't decide those things. Those are juries.
Absolutely, Your Honor.
Be much more efficient if you just waive all the jury trials and let me do it, but constitutionally, I don't think you probably would do that.
No, Judge.
I don't see a reason to put this off, really. But we can set it for a trial, and then you can have your motion before the trial. You have your calendar with you?
Yes.
We need to set it out past the 19th of March so we can have this. Do you really think that the O'Donnell, measure will take 2 days?
Uh,
56.
it depends on the court. There's a motion to suppress where his confession may have to be played. That'll be Detective Burton.
Yeah.
And
Well,
then
let's
there's
try
two
the
witnesses.
27th then.
Okay. we
That's
could
on
do-
Wednesday.
Yeah.
27th for your client, March 27th. That way you can have your motions on the 19th.
Sure.
I work that day. I have a conflict I already see because I'm already 2 places that day. One of which being in district court in this courtroom.
Well, I don't know whether this report will be in this courtroom if I schedule.
I'll be down that, somebody be downstairs, Judge. That's also a day, Your Honor, that Clinton District Court also meets.
The Clinton trial on the March the 9th with Tucker, what kind of involvement?
On April the 9th. That's the one we discussed a while ago, about the minor section of the
I mean, is it,
advice.
you think that'll last over a day?
No,
Let's go into the 10th, then. March 10th. That's a Wednesday too. Never mind.
Judge, I can make that work.
No, well, I don't want to do that to Judge Chris. Let's do it on, March the 8th.
I mean, April the 8th, Your Honor.
I mean, April 8th, excuse me.
Yeah, that's fine with Commonwealth.
Perfect for us, Judge. Go.
Saturday, just Saturday. Really just got back from practice, so. I'll do it all. Okay.
Okay. Kevin Cooper. Mr. Poindexter, is this your case, Kevin Cooper?
Sorry.
Commonwealth versus Kevin Cooper, 23 CR 0073. Are you Kevin Cooper?
Yes, Your Honor.
Born in 1997.
Yes, Your Honor.
Last 4 digits of social security number 9637.
Yes, Your Honor.
Here on the pretrial conference where we have.
We have a pretrial diversion, Your Honor.
This is
Okay,
proposed.
just hold it there. You have to identify his signature, please, okay? Go down through. A motion's been tendered, sir, that says you wish to enter plea today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes, Your Honor.
Are you the same person named in the indictment that I just read?
Yes, Your Honor.
Is your judgment impaired today in any way?
No, Your Honor.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, Your
Have
Honor.
you reviewed the evidence Commonwealth has against you? Do you believe you're fully informed about your case?
Yes, Your Honor.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can do the same thing. You have the right to speed trial by jury, the right to be represented as counsel at your jury trial. right to confront and cross examine all witnesses called testify against you, right to produce evidence, right to call witnesses in your favor, right to fill this matter to hire court if you lose. I have the right to fight a commonwealth prove on a reasonable doubt that you are guilty of charged against you. Understand by entering your guilty plea today, you give up those rights. You understand that?
Yes, Your Honor.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. In the event that I don't accept the recommendation, you decide to impose a harsher sentence. You have the right to withdraw your plea and proceed to trial. Now, I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No, Your Honor.
Any felonies in the last 10 years?
No, Your Honor.
Are you presently under probation or parole?
No, Your Honor.
You understand if you complete the diversions, you could have the charges dismissed, pretrial diverted, dismissed, and have your record expunged. You
Yes,
understand
sir.
that? But if you don't successfully complete, you're brought back before me, and I avoid your pretrial diversion. I'll schedule for the pre-sentence investigation report. And in a sense, you'll be a convicted felon, and that can be used against you in the future if you have additional felonies. You understand that?
Yes, Your Honor.
Mr. Stockton, what is the Commonwealth's recommendation in this case?
Your Honor, Mr. Cooper would plead guilty to possession of controlled substance, first degree, receive a sentence of 3 years, pretrial diverted for 5 years, be supervised. He'll plead to failure to maintain insurance, a $50 fine. He'll also, Commonwealth, we're tendering an information indictment on carrying a concealed deadly weapon. He'd receive a sentence of 12 months, 60 days home incarceration, balance probated for 2 years, pay a fine of $300. The shotgun would be forfeited and destroyed by the Commonwealth. All fines and court costs be paid at the discretion of the court. He'd obtain and maintain gains of employment. This is the case, if you recall, he had 2 10,000ths of a gram of methamphetamine on him. He also had the shotgun with the barrel taken off. So we've done the information on that. It's a misdemeanor. And I've done the 12 months with the 60 days home incarceration.
How is it a crime at all?
Because the gun was, if it was assembled, it would be less than the 18-inch length. Reason to be a crime.
Yeah. And what did you give him on that weapon?
So it's a misdemeanor with 12 months, 12 months sentence, 60 days home incarceration with a $300 fine.
You want him to serve 60 days?
I put home incarceration so he can work, Your Honor. Like, he can maintain employment.
He's got a full-time job, Your Honor.
Where's he working?
Tractor Supply Company in Columbia. And he's had an ankle monitor on for, I think, 90 days now.
What are you gonna do with those now?
I was gonna make him serve the additional 60 myself, so. I hate it. He's been on it that long, but I think that's appropriate in this case.
Is that what you agreed to?
Yes, Your Honor.
Are you pleading guilty because you committed acts charged in the indictment?
Yes, Your Honor.
You do so your own free will?
Yes, Your Honor.
No, your constitutional rights explained to you. Is it still your desire to allow the court to fix your punishment?
Yes, Your Honor.
Okay, is that your signature on the document?
Yes, Your Honor.
Okay, now I'm gonna accept this agreement. But I want you to know that you came very close to having some drugs on you and a sawed-off shotgun. You had a minute amount of drugs. Okay, but having a sawed-off shotgun, there's absolutely no legitimate purpose for having an illegal sawed-off shotgun concealed in your vehicle, whether it's assembled or not. So I'm gonna be watching you. Okay, if you violate this, don't come back and ask the court for any lenience, because there are people getting killed all over America because you have a gun around you when you're using drugs. Combination of using drugs and having a gun close to you is not a good combination. And a lot of people that deal in drugs, and I'm not saying you deal in drugs, but a lot of people that deal in drugs would be foolish if they didn't have a gun around them because somebody's going to rob them. So the combination of all that things is why getting people killed, and you could be one of them. So you go ahead and meet with the probation and parole officer. That's your signature on that document?
Yes, Your Honor.
Okay, I'll sign it today.
Just be
Thank you.
$75.
$575. You need some time to pay that?
I could probably pay that today.
Okay, you can do it then. Okay, thank you.
Thank you, Your Honor.
Okay, now we have Keaton Cross here on the docket, and it says, written in, that he's in the Clinton County Jail.
That's correct.
Okay, we don't have a connection with the Clinton County Jail today. So
Judge, they're gonna be on at 10 o'clock.
10 o'clock, okay. Brett Davis. Brett Davis. Brett Davis.
I really don't know why this one is on. It's set for trial next month, and Mr. Stockton and I are still talking about trying to resolve it, but I'd sent your office an email yesterday advising that Mr. Davis is employed in Cedar Rapids, Iowa, trying to.
What do you have to say, Mr. Stock? Why is it on the dock?
I don't know unless it's just for a status conference.
No, there's an out-of-state witness, y'all know.
Yes, that's correct. We have one witness that's in Tennessee. We're trying to get a subpoena domesticated.
Okay, I'll sign it.
Yeah.
Is this set for trial when?
April 16th. April 16th.
Okay. Jennifer Farley. Is it hot in here?
I don't know.
See what the temperature is. Okay, it's all right then. Commonwealth versus Jennifer Fairley, 23 CR 00112. Are you Jennifer Fairley?
Yes, sir.
Born in 1972, last four digits, social security number 8590.
Yes.
We're here for a pretrial conference. What's the Commonwealth have to say?
We've not made any progress as far as settling the case yet.
Are you going to set a trial date?
I think Mr. Frost wanted some additional time. I don't know how much you want. Your Honor, our discussion with Mr. Stockton was we'll have to have access to various medical records.
What is the charge?
This is a case where she's accused of taking medicine at the nursing home here locally, Your Honor. Controlled substances. It's going to take a while. I told Mr. Stockton what I want, but I've not particularized it in writing. I need to do that.
Well, you have what you need to prosecute. The only thing he's required to give you is what he has.
I'm a little confused, Your Honor.
Well, if you file a discovery motion, then he has to give you what he has.
Right.
He doesn't have to go get other things to give you. Why would, I don't understand, am I correct on the discovery?
Yeah, I don't know what he
What are you
wants.
talking? What are you asking?
We need medical records from the nursing home regarding certain individuals who allegedly had medication, which was.
Well, do you have that information?
No, that would be something, I think he'd have to file a motion. They'd have to be a court order before that could even be a.
That's why I'm saying he can't get it.
Well, if that's the way you want us to proceed, we'll be happy to do that, Your Honor.
Well, if you think you have to have it, you need.
Well,
to do
I
that.
mean, that wasn't our discussion with Mr. Stockton, but you know, if that's the
Like
way
we've
the
got
court
that
wants us to
detail,
proceed,
but-
we'll be happy to do that.
Yeah, she'll have to get a court order before they'll furnish those items.
That's right.
Yeah.
They got HIPAA and all those other acronyms. Why don't you get an agreed order on that rather than file the motion? Why don't you
I'll file
prepare
the
an agreed order where the Commonwealth has no objection to those sort of things? And then you have to include in there that they'll be under seal, that the information won't be available to anyone but counsel. And the normal hoops you have to do on HIPAA. Okay, we'll schedule this, assuming that we can get this in time, we'll schedule you a pretrial for March 19th. On that day, we'll either have a resolution or we'll send trial.
I don't believe I'll be here on the 19th. I can send Ms. Fields if need be, but
That'd be okay. If you got an agreement, you can send her. If you don't have an agreement, she can bring your calendar. We won't do anything substantive without your
Thank you, Your
presence. Okay.
But I hope we can get this stuff done. But we'll see.
Yeah. David Hammer. Commonwealth versus David Hammer, 23 CR 0027. Are you David Hammer, sir?
Yes, sir.
You born in 1987?
Yes, sir.
Last four digits of your social security number 2513. Is that correct?
2512.
12?
Yes, sir.
Please take note of that. See if it's a typo or whatever. We're here for a probation revocation, was it Commonwealth?
Your Honor, I initially filed this motion because I received a report on February the eighth that Mr. Hammer had absconded. Since then, Mr. Collins got in touch with me and told me that Miss Bennett, who's, I don't know if she's on the line or not, supposed to be Monica Bennett. Evidently, Mr. Hammer had reported, he's in good standing now, he's got a job, he's working, he's doing SAF IOP. And everything's fine with Miss Bennett. I was gonna move to withdraw the motion.
Ms. Bennett, are you in accord with that? She needs to turn.
Yes, I am.
Okay, we'll go forth. Mr. Hammer, and
Thank you,
be
Judge.
of good comport. We won't see you back here.
So have a good day.
Okay.
Your Honor, that's all I have today. May I be dismissed?
Absolutely. Thank you so
Thank
much.
you.
Concepcion Lopez. Sentence.
Good morning, Your Honor. This is Elisa Casanova, Supreme Court Certified Spanish Interpreter to assist you with Mrs. Lopez's case.
Okay, will you turn your camera on so Mr. Lopez can see you? Ma'am, will you raise your right hand? You swear that the interpretation will be the true and correct, and as you have stated that you recognize in the Commonwealth of Kentucky Administrative Office of Court as a qualified legal interpreter.
Yes, I do, Your Honor.
Thank you very much. Are you Concepcion Lopez?
¿Es usted la señora Concepción López?
Sí.
Señor, yes.
Were you born in 1977?
Su año de nacimiento es el 1977.
Hey.
Correct.
You're here for sentencing. You
Estamos
understand
aquí
that?
para la sentencia de su caso.
No lo escuché, perdón.
Estamos aquí para la sentencia de su caso.
Oh, ok.
Okay.
Okay, have you had an opportunity to look at the pre-sentence investigation report?
¿Has podido echarle un vistazo al informe de la investigación previa a la sentencia? ¿Perdón?
Mande, perdón.
Okay, telling me that the sound comes from over there. He speaks directly into the microphone and she can hear him, okay?
Speaking to talking.
Hable usted al micrófono.
Ok.
Okay.
Have you had an opportunity to review the pre-sentence investigation report?
Caballero, el informe que se ha escrito antes de la sentencia, ¿usted lo ha leído?
Sí, sí.
Yes,
Is it substantially correct?
Es correcto.
Así es.
Okay.
It is.
Counselor, is there any reason this gentleman should not be sentenced today?
No.
¿Alguna razón por la que no podamos proceder? Ninguna.
Me lo repite.
Can you repeat?
Is there any reason this gentleman should not be sentenced today?
El juez está indicando simplemente si hay razón para no poder proceder hoy. Y el abogado ha respondido que no hay ninguna razón para no proceder, que sí pueden proceder.
Sí, sí, que proceda, sí, claro.
No.
Yes, and we can proceed, of course.
Ok.
On a plea of guilty to possession of controlled substance, first degree, the defendant shall receive a sentence of 3 years, probated for 5 years.
A este cargo de estar en posesión de una sustancia controlada, la condena de cárcel sería de 3 años, pero estará usted en libertad condicional durante 5 años.
The defendant shall serve 30 days in jail in addition to the home incarceration.
Al margen del tiempo de arresto domiciliario, cumplirá 30 días de cárcel.
The defendant will obtain gainful employment or do 30 hours community service until he is employed.
El acusado tendrá que tener un empleo regular o hacer 30 horas de trabajos comunitarios hasta que pueda tener un empleo.
He agrees that all drug paraphernalia and contraband shall be disposed of in accordance with law.
Y tendrá que dar su consentimiento para que se pueda desechar cualquier tipo de droga o elemento de contrabando incautado por la policía.
Now, counselor, I understand that he shall serve 30 additional days in jail under this plea?
No, Your Honor, he actually has served his time and should have credit for time served. There was an amendment to,
Okay, you need to slow up, and let her.
Señoría, creo que los 30 días no los va a tener que cumplir, ya que él ha cumplido ya tiempo suficiente y se le va a dar crédito por los días de cárcel que ya ha cumplido.
Is that your understanding, Mr. Stockton? He already has his time served. Okay, what is his court costs involved in this?
El juez le pregunta al señor Stockton si es cierto que ya ha cumplido el tiempo de cárcel exigido y está preguntando cuántos son las costas judiciales a aplicar.
What's the court cost?
$265.
265? You have court costs of $265. You need some time to pay that?
Tendrá que abonar $265 en concepto de costas judiciales. ¿Cuánto tiempo necesita para pagarlo?
No sé, pero si me puede dejar, dígale por mes, porque acabo de empezar a trabajar, dígale.
I don't know. I think if you can give me 1 month, because I just now started my new job.
I will allow you to pay $30 a month. The first payment will be 30 days from today, so you can get on your feet.
Le voy a permitir que pague $30 al mes y su primer pago se tendrá que hacer dentro de 30 días. Así no tendrá usted dificultad para poder salir adelante.
Okay, you'll need to meet with the probation and parole officer. I'm gonna have him come forward, the probation and parole officer, so we can establish a time that they'll have an interpreter available at the probation and parole office. When can you meet with this gentleman?
El Departamento de Régimen Probatorio tendrá que concertar una cita con usted para poder tener un intérprete presente.
Monday, I think it's March the 4th.
Este próximo lunes, que es 4 de marzo,
What time?
9 a.m.
a las
Yeah.
9 de la mañana.
What location?
They'll be at the Columbia office,
Columbia, Kentucky office. What's the street address there?
116 Jamestown Street.
Y será en la oficina de Columbia, Kentucky, en el número 116 de James Street.
116 Jamestown Street, Columbia, Kentucky, 9 a.m. Monday morning.
116 Jamestown Street, en la oficina de Columbia, Kentucky, a las 9 de la mañana, el próximo lunes 4 de marzo.
Okay, thank you very much.
Muchísimas gracias.
We have a need for interpreter to the rest of the document. Thank you for your attendance, Madam Interpreter. You may be excused.
Thank you, Your Honor.
Yeah. Charles McCoy. Charles McCoy. Commonwealth versus Charles McCoy. Commonwealth versus Charles McCoy. What says you, counsel?
Well, Your Honor, Mr. Stockton and I were discussing this. We had received the order finding him incompetent based on a previous hearing, so we weren't sure if it was just a status or.
Where is Mr. McCoy now?
I think he's residing his sister's here in the courtroom. I believe he's residing back at home.
If it's got a suitable housing and it can stay out of trouble,
Call
then I
his
won't
sister.
file it.
Come- Sandy, come up here for a second.
And I believe the district court case with the guardianship is still ongoing.
Come up here for a second. Yeah, I think it'd be appropriate to inquire of her. She's here in Nashville, I would assume. Where is Charles now?
I don't know,
Is he down at Charles' home place down there?
not that I'm aware of.
When's the last time you saw or heard of Charles?
Last time I saw him was, I don't know the date, but it's around, it's after Christmas, Sunday break. He
Yes.
usually doesn't call me unless, or talk to me unless he needs financial.
Yeah, I got you.
Has a guardianship been established yet? Okay.
Well, they can't ever They can't ever get a jury to find him not competent.
Well, I guess I'll,
He beats them every time that they go to jury
well,
trial.
I guess we'll see if he can beat a 2028 petition. That's what I'll have
You
to
know what I
file.
mean?
Yeah, that's what I'll be filing under these circumstances.
Then we'll try to serve him. I mean, I'm not only concerned about these charges, I'm concerned about his welfare, where he might be when he's got out. You know, if somebody, in the past, we've seen situations where people might be taking advantage of him. Okay, well, thank you for cooperating.
Thank you,
You
Your
may be excused. Let's go ahead and schedule him at 2:02 and then,
I'll schedule that for the 19th, if that's all right.
okay.
And, Ms. Holly Perigin was representing him as his guardian ad litem in the last petition. I know she has a good relationship
Okay,
with
we'll
him.
continue that. She's in the south end of the county, so we trust her somewhat. compared to the rest of us. Okay, Commonwealth versus Charles Perkins. Are you Charles Perkins?
Yes, sir.
Were you born in 1981?
Yes, sir.
Last four digits of your social security number 9080.
Yes.
We're here for the pretrial conference. What does the Commonwealth have to say?
Your Honor, we met at the negotiation day and I thought we made progress, but Mr. Perkins had to go to the child support office and tender some information about getting his child support recalculated. We're waiting on that, so if we can have one more negotiation day, we should be able to wrap this up.
Negotiation date at 1 p.m. on March the 8th. The next court day is March the 19th.
Thank you.
Michael Riley. Michael Riley. Commonwealth versus Michael Riley, 24 CR 004. Are you Michael Riley, sir?
Yes, Your Honor.
Born in 2000.
Yes, Your Honor.
Last four digits of your social security number 6104.
Yes, Your Honor.
You're here for the purpose of arraignment. You have a right to remain silent. You are represented by counsel. The grand jury of Cumberland County has charged you with rape in the third degree, violation of KRS 510.060. You understand what the charge is?
Yes, Your Honor.
Okay. Mr. Poindexter, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
We do, Your Honor.
Okay, we'll schedule this for negotiation at 1 p.m. on March the 8th, and the next court date's on March the 19th. What are the conditions of this gentleman's bond? Conditions of his bond.
I'm gonna make a monitor, have a switch on monitoring, no contact with no new arrests. Make all scheduled court appearances. No illegal use of alcohol or controlled substance, not consume any alcohol or drugs, not violate any local state or local law.
Okay, now, are you working anywhere?
Tyson.
Do what?
Tyson.
Will they allow you to work with your ankle monitor on?
Yes, sir.
Okay, well, I'm not gonna change that. So you can go to work, home, church, or the doctor. Okay, those are additional. And and you can come see your lawyer if you need to.
Yes, sir.
Okay? Okay, thank you very much.
Thank you, Your Honor.
Eddie Scott. Eddie Scott, active warrant out for Eric. Eddie Scott. Jacob Smith. Commonwealth versus Jacob Smith, 23 CR 00111. Are you Jacob Smith?
Yes, sir.
Born in 1991. Last four digits, social security number 5088. You're here for a pretrial conference.
We have an agreement as of this morning. We're doing the paperwork. Right?
Okay, we'll just pass over and come back. Okay, if you want to take a seat, we'll call you as soon as the paperwork's finished. Keith Smith. Commonwealth versus Keith Smith, 26 CR 0024. Are you Keith Smith?
Yes, sir.
You were born in 1963.
Yes.
Last four digits, social security number 8253.
So,
Have a pretrial conference. What we got here?
felony plea, Your Honor.
You got a plea? A motion been tendered, Mr. Smith, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in the indictment that I just called?
Yes, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. I need to know that you understand before I can accept a plea. I'm going down through these rights. At the end, I'm going to ask you if you understand, okay? You have the right not to testify against yourself. No one can make you say anything. Right to speed trial by jury. Right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. The right to fill this matter at higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges. You understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will await a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you'll have the right to withdraw your plea of guilty and proceed to trial. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a handgun by a convicted felon, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 3 years. Upon a plea of guilty to operating a motor vehicle, an alcohol concentration of or above 0.08, or while under the influence of alcohol or other substances first offense, aggravating circumstances, the defendant shall pay a fine of $300 and serve 7 days. All sentences are to run concurrently for a total of 5 years, serve 90 days, balance probated for 5 years. The defendant agrees to be assessed by the social services clinician and will follow any recommendations thereof. The defendant shall pay a fine and court costs at the discretion of the court. The defendant agrees to have any and all drugs, paraphernalia, and contraband disposed of in accordance with laws of the Commonwealth of Kentucky. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Is that what you agreed to, Keith?
Is that what you've agreed to? Yeah. Yes.
Are you pleading guilty because you committed acts charged in the indictment? You plead guilty of your own free will.
Yes.
Knowing your constitutional rights is still your desire to give up those rights and allow the court to fix your punishment. You understand that by entering this plea, any future convictions will enhance the range of penalties. You understand that?
Yes, sir.
Okay. Is that your signature on the document? Okay, I'm over a pre-sentence investigation report. Schedule your sentencing for March 19th. Now, how many days on the ankle monitor was he supposed to have?
90 days to serve.
90 days to serve. Okay. Okay, well, you're in the custody of the jailer.
Your Honor, two things. Number one, we've already got a DUI guilty plea. We need to go over it if you want to do it today or at final. And number two, Keith's, like what his sister gets in, could he report at 6 o'clock this evening?
Okay, the DUI, there was a DUI included in that. The only thing I need to know about the DUI is that you understand that the DUI is enhanceable also. If you get another DUI, it'll be a more serious charge. You understand that? Okay, is there anything else about the DUI you want him to say?
It's fine. Just didn't want it to be
That's right.
overlooked.
You can turn yourself into jail today at 6 o'clock, the Adair County Jail.
Okay.
And what we're finding court costs, yeah,
$890.
$890. I'll wait till you get out of jail and you can start paying it at $60 a month. 30 days after you get out of jail, okay?
Okay.
Okay, thank you. Jennifer Spears. Commonwealth of Kentucky versus Jennifer Spears, 23 CR 0091. Are you Jennifer Spears?
Yes.
You born in 1985?
Yes.
Last 4 digits, social security number 6051.
Yes.
You're here today on a pretrial conference. We all have it announced.
We do, Judge. We have a pretrial diversion plea.
Okay. Ms. Spears, a motion has been tendered, says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Do what?
Is this plea freely and voluntarily given?
Yes.
Okay, are you the same person named in the indictment that I just announced a few minutes ago, a few seconds ago, 91?
Yes.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you and you feel like you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept pleading guilty, I need to know that you fully understand those rights.
Yes, sir.
I'm gonna go down through the rights and I'm gonna ask you to understand. If you have any question, you can step away from the podium and ask your attorney. You have a right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury, your right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses, call testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to fire the Commonwealth prove beyond a reasonable doubt that you are guilty charged against you. Understand that entering guilty plea today, you give up those rights. Do you understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided law. I don't have to accept the recommendation. If the event that I do not accept the recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea and go to trial. Now, I'm gonna ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No.
Have you had any felonies in the past 10 years?
No.
Are you currently on probation? Are you currently on probation? Well, I mean, you seem
No,
to.
I'm not.
I think she was inquiring about this
Yeah,
case, Judge.
this
So,
case.
Okay. You understand that if you complete the diversion program, the charges could be dismissed, pretrial diverted, and you can have your record expunged. Do you understand that? You understand if you do not successfully complete the program and you're brought back in front of me and I avoid your pretrial diversion, I'll schedule you pre-sentence investigation report. You'll be sentenced, you'll be a convicted felon, and any felonies that you have in the future in the Commonwealth of Kentucky, the sentence could be enhanced because of this plea. You understand that? What is the Commonwealth's recommendation? Gordon Anderson?
Upon a plea of guilty to theft by unlawful taking over $1,000, the defendant shall receive a sentence of 5 years, pretrial diverted for 5 years. Diversion is to be supervised. Defendant agrees to pay restitution in the amount of $9,000 to the estate of Anthony James Tony Riddle on behalf of the minor child AR, payable through the Cumberland County Circuit Court Clerk's Office restricted bank account. The first payment being due on March the 1st of 2024 in the amount of $100 for 6 months. Beginning on September 1st of 2024, the defendant shall pay $200 per month due on the first of each month thereafter, first day of each month thereafter, until paid in full. The defendant shall obtain gainful employment or do 30 hours per week of community service if gainful employment is obtained.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes.
Okay, you're doing so of your own free will.
Yes.
You know, your constitutional rights is still your desire to enter guilty plea and allow the court to fix punishments required by law. Is that your signature on the document?
Yes, sir.
Explain to me exactly what happened here.
Judge, this was an issue where, say allegedly, Ms. Spears had access to a bank account that was a trust account for a minor child. The funds in that account were depleted.
What was the relationship she had with the child?
The son, it was her son, or is her son.
Yes, Your Honor, this is the case where if the things had been done properly and these items had been approved, most of this would have been approved, but since it wasn't done by the district court, then I believe this is the appropriate amount to pay back.
Okay. Okay, you meet with I'll go ahead and sign the agreement. You go ahead and meet with the probation and parole officer. Okay. Get her back up here.
Jennifer.
Including other restitution, you owe court costs of $185, so you can pay that at $30 a month, starting 30 days from today, okay? Thank you. Jamie Stearns, sentencing. Commonwealth Wilson Jamie Stearns for sentencing. You are Jamie Stearns.
Yes, sir.
You're born in 1977.
Yes, sir.
Last 4 digits of your social security number 4748.
Yes, sir.
You're on 23 CR 0098, 23 CR 00105 for sentencing. Have you had an opportunity to look at the precinct's investigation report?
Yes, sir.
Is it substantially correct?
Yes, Judge.
Is there any reason this gentleman should not be sentenced today, counsel?
No, Your Honor.
Okay, upon a plea of guilty possession of controlled substance, first degree, 3 counts and 23 CR 098, he shall receive a sentence of 2.5 years on each to run concurrently for a total of 2.5 years. On plea of guilty failure to maintain insurance and 23 CR 0098, he should receive a fine of $500. On plea of guilty to possession of controlled substance and 23 CR 0002, he should receive a sentence of 2.5 years. Sentence on 23 CR 0098, 23 CR 102 shall run consecutively for a total of 5 years, probated for 5 years, supervised you. So he shall receive credit for time. Service shall be assessed by social services commission and paid fine and court cost of.
For both cases, it's $890.
Okay. Is that separate court costs for both of them?
Yeah.
I'll combine the court costs, just the court cost section of it. Save you $100 and something bucks.
Thank you, Judge.
They said 40.
740, can you pay that today? You need some time. Okay, you pay it $50 a month, starting 30 days from today. Okay? And I'll say you need to meet with probation and parole. Jason, Servicing. Looks like an active warrant.
Yeah, we'll put him in CIC.
Okay. Sean Thacker.
Same, Your Honor. Oh, no, this is a motion to forfeit guns. I don't know.
There's an active warrant out.
I don't know if you want to wait till he's in custody, if we can go ahead and tender an order. It's a motion. to
What's he
forfeit
charged with?
guns.
Let's wait till we get him in custody. Okay.
Yes. This was a convicted felon in possession of a handgun. He's already been convicted. I don't know why there's that. Yeah.
So Judge, I don't think the one, and I would have no objection given his status, but if the court needs to have him, I understand.
So he's already been convicted of a felon.
Yeah, but what about the forfeiture of the gun? The gun has already been forfeited?
Well, I thought we put it in a plea agreement, but we didn't. We put in there the defendant agrees to have all drug paraphernalia and contraband disposed of, but we didn't put anything in there about the
Well, I
gun.
guess that gun is contraband.
Yeah, so I'll tender an order if it's all right in court.
There's one in the file.
Okay.
Okay. Tammy Weaver. Tammy Weaver.
Judge, this says motion for probation. I didn't file it, but.
She was
So I
in,
guess you'd be in custody if.
she was in specialty court in Daviess County through this case, and evidently she had some health issues and they administratively discharged her. So I was wanting to do an order to put her back on regular probation.
No objection.
Where is she?
I don't know. If probation pro can't find her, I'll probably be filing a motion to revoke.
Y'all know where she is?
She's already reported to me, Your Honor. I've already got her in the cycle of reporting.
So
You
that's-
satisfied with being put on regular probation? You think manager okay?
I think she'll be fine, Your
She's
Honor.
the one
Okay.
that lady.
I'll sign an order.
Cancer.
I'll sign an order since you've self-reported when she got discharged. Last one on the active docket that Nicholas Ray. Nicholas Ray. Commonwealth versus Nicholas Ray, 24 CR 002. Are you Nicholas Ray?
Yes, sir.
Were you born in 1999?
Yes, sir.
Last 4 digits, social security number 1919.
Yes, sir.
You have a right to remain silent if you're represented by the office. You have an attorney.
Don't forget, I think, you know,
Public advocacy, got the appointment. You have a right to remain silent. You have any questions, step away from the podium. The grand jury of Cumberland County has entered indictment charging you with possession of controlled substance, first degree possession of drug paraphernalia. Mr. Bailiff. You acknowledge the identity of your client received indictment away from or reading Raymond enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order which requires the Commonwealth to provide you evidence they have in your case. Your negotiation day will be March 8th, 1 p.m. Next court date will be March 19th, okay? Okay, I'm gonna go to Barron County. I'll come back here, I guess we got Jacob Smith paperwork to be done.
And
And we have Keaton Cross, who's in Clinton County Jail later.
Judge, we also have Mr. Alexander.
Yeah, well, we'll come back to him, okay? Barron County, are you on there?
Yes, Your Honor.
If you're not Barron County, turn your camera off. Okay, this is Barron County, Commonwealth, Kentucky versus Johnny Gold. Are you John Gold? Okay, we'll have a motion for shock probation. What do you have, Mr. Poindexter?
Your Honor, Mr. Goode was final sentenced November 16th. He had jail custody credit prior to that. So all total, he's got approximately 200 days of credit at this point. We're asking that he be released on shock probation. I believe, I'm not sure, that this may have been his first. No, it's not his first felony. I'm sorry. So we're just asking after 200 days served on this sentence, we believe that he would be eligible for shock probation, and that would be the best result.
Mr. Stockton, what kind of charge is this?
This is a possession case, Your Honor. The problem he had is when they went to Barron County on a probation violation, he had a handgun near himself on a chair, and he had a bunch of rifles and shotguns in a safe hit. That was the reason for revocation. So he was not eligible for parole till November 24th. He's got to serve out of another year and 7 months, and he's been in 6 months and 20 days. So it's a possession charge is what he's in for.
What about, was he charged with the weapons?
That was in Barron County, and I've not run a court net review since. That maybe pretrial could help us out and see what's happened
It's
to
still
Barron
pending.
County. It's still pending.
Yeah, it's still pending in Barron County. I think the benefit of the shock probation, Your Honor, would be that this court would control where he is and what he's doing. Whereas if we wait and Department of Corrections paroles him out, then this court has no.
I'm not interested in controlling what he does. I'm interested in, a convicted felon having a bunch of guns there and pulling a new charge is what I'm concerned about.
Yes, sir.
But I will wait till there's a disposition of those charges over in Barron County before I prejudice it by this. And if they don't dispose of them, you can call the witnesses to come over here and testify. I don't think it would be right to deny his motion for shock probation without at least some factual finding.
Yeah, well, we could probably, when we had the hearing, I believe I had the Barron County officers testify before. We could probably just pull the hearing out.
That'd be good.
Review it.
I'd forgotten we had a hearing on it.
I think we did. My memory's faulty, but I thought we had a hearing on. I had the Barron County officer over here when we did the revocation.
I don't.
Well, we'll check on that. If we did, I'll treat this as a submitted motion and I'll review that evidence that's already in the record.
If not, I'll.
Yes, sir.
Thank you.
Thank you, Judge.
I don't think we have anything else in Barron County. Barron County, thank you for your cooperation. We have Hart County. Hart County, are you on there? Hart County.
Yes, sir, Your Honor.
Randy Metter. Commonwealth versus Randy Metter. Are you Randy Metter?
Yes, sir.
Were you born in 1980?
Yes, sir.
Last 4 digits, social security number 2068.
Yes, sir.
We're here today for 19 CR 0078. For the shock probation revocation. What does the Commonwealth have?
Your Honor, this is a motion to revoke shock probation. Mr. Metter picked up a new felony charge in Edmondson Circuit Court, possession of a handgun 9mm Ruger. That's the basis for the revocation.
Y'all want to stipulate to that?
Mr. Mayor, you want to stipulate to revoking your pretrial diversion?
Yes, I would like to speak to a lawyer and talk to him about it, Your Honor.
Okay, you got a lawyer here.
Yeah, but I didn't know nothing about this.
Okay, go ahead.
Well, I didn't know nothing about the case today, and they come about me today because
Okay,
the
well,
bond case.
I'll give you time for this lawyer to come see you.
I have a question, Your Honor. Is there a bond in this case? Because
No.
I'm on bond. I have a signature bond on the gun charge. They let me sign myself out on it.
No, I'm not gonna let you out till we till we find something more about this. Cause you're you're on shock probation and they charge you with a weapon. Now, if I get testimony on it and I find it's not, or if they do the resolution down there. So
I'll have the officer.
I'll have an officer, I'll have this lawyer talk to you about it, and after he finds out some information, he can contact directly the Commonwealth attorney, and if the Commonwealth's in agreement with the bond, I won't oppose that. But it's a serious charge here, and until you get an attorney in before me, I can't do anything. And we have an officer online here.
That's Mr. Bray. Yes, he's the supervisor.
Mr. Bray, were you involved in this case here?
I'm a supervising officer, but no, Your Honor, I was not involved in the arrest
Yeah,
in Edmonson County. That was a Deputy Tim Jackson, Edmonson County.
okay. Okay, well, we'll get in contact that. Mr. Mitter, I'd say that your attorney will be in contact in the next very few days. Is that correct?
That's correct, Judge.
Okay, thank you very much, Hart County. You may be excused. Let's go to Knox County.
Your Honor, this is the only case I have. May I be excused?
Absolutely, thank you.
Thank you.
Go to Knox County Detention Center. Are you on there? Knox County does not appear to be on there. Knox County, Meade County. Let's go to Meade County. Meade County. There you go. Yeah, Commonwealth, thank you very much. Commonwealth, Kentucky versus Joshua Duval. Joshua Duval.
Yes, sir.
Mr. Duval, you're here on 43 CR 00030. Were you born in 1985?
Yes, sir.
Last four digits, social security number 4641.
Yes, sir.
Here on a motion for shock probation.
Yes, sir.
What do we have?
And Judge, if I kind of take the lead, and this was filed as much as anything to preserve the issue. Mr. Duval is in this in-between area where he's set to go up for parole April 11th. Commonwealth has agreed to the shock and into a specialty court for Mr. Duval. But I just want to have the opportunity to talk to him and explain the difference in him coming out on shock probation in a few weeks versus potential parole in a little bit over a month.
Yeah, my question was, is he gonna be living here in Cumberland County?
Speak up just a little bit.
I was gonna agree to it if he's gonna be living here in Cumberland County.
That would be correct, Judge. His mother's actually here in court and the hand of Mr. Alexander. Well, that's what, her sister of Mr. Alexander. So he would be residing, coming into specialty court here in Cumberland County.
He has a 3-year possession, so.
So, Mr. Duval, what your attorney is saying, is he's gonna explain the advantages and disadvantages on being on parole versus being on probation and going to drug court. He's gonna compare the two of them, and he's gonna be in contact with you in the next couple of days. Counsel, is that what you're saying?
That is correct, Josh.
I'm not saying that you weren't clear, but because I'll just make sure you heard it. Okay, and so I'll be available to look at an agreed order if there's an agreed order on it. Okay, so your attorney will be in contact with you, Mr. Duval, okay?
Yes, sir. Yes, sir. Thank you.
Thank you, Meade County. You may be excused.
Thank you, Your Honor.
Let's go to Adair. Well, we don't go to Adair County for 30 minutes, so we've still got the possibility of Knox County coming on. If somebody could contact Knox County, Barberville. And now we also got, we also have, Kenneth Alexander. Y'all got him ready?
Yeah, I'm ready for a trial date.
What? Paperwork.
Oh, I thought it was getting trial date, so.
You got paperwork ready on him?
We do not, Judge. We'll be entering
We
the,
almost have Mr. Smith's ready, but.
Okay, well, let's go in recess and y'all got 15 minutes or so that you won't be called up here before we come back from 10:30 jail docket. Well, is Clinton County on there? We do have one Clinton County case. Sorry. Clinton County, I see you on there. Y'all gonna be on there at 10. Keaton Cross. Keaton Cross, Clinton County. Hey, are you Keaton Cross?
Yes, sir.
This is 23 CR 006. Cross, were you born in 1999?
Yes, sir.
That's 4 digits, social security number 1745.
Yes, sir.
Now, this was a motion to withdraw by Ms. Perigin. You standing in for her is,
no, Judge.
well, what are you up here for?
Well, Judge, I know with Ms. Purge and
Okay.
withdrawing, what's the ultimate result of that, as I represent Mr. Cross and other matters.
Anticipation, you're anticipating.
I'm just standing here, Judge, saving me some few steps today.
Okay, this is a pretrial diversion revocation. There's Carson Payne on there. He was in orange. I thought he was another inmate. Didn't realize you ought to dress more discerningly, Mr. Payne. You're wear blue or red or whatever.
I'll try to do that next time, sir.
Okay. Okay, well, your attorney will be allowed to withdraw, Mr. Cross, and so you, Mr. Cross, you have another attorney?
No.
Okay, the way this works, Cross, is if you hire an attorney and you don't pay them, then they don't represent you. Now, I will have to get you to fill out an affidavit to see if you're eligible to receive a public advocate, but until then, until we get the paperwork done, we'll go ahead and appoint temporarily.
And Judge, I confirm that in Clinton District Court,
Yeah.
recently, Mr. Cross completed the requisite affidavit.
Okay, well, I'll
Qualified,
accept
so
that. I've accepted your testimony on things of more.
that wasn't even
greater
expert
note than
testimony,
that.
Judge.
Okay, well, I'll go ahead and appoint you now. You'll have
And Judge, if we could.
this is
set
a motion for a pretrial diversion revocation. So we'll just have this scheduled to heard on the next rule date, March 19th.
Yes, and if we could set this for the March 8th negotiation, he's probably gonna be indicted in Clinton County. We might be able to wrap both cases.
Okay, March 8th for negotiation at 1 PM. And then the 19th case will come back here.
Thank you, Judge. Keaton, I'll be able to talk to you soon.
Okay. You may be excused, Mr. Payne.
Thank you, Judge.
Thank you. Okay, let's go in recess here. You gonna be working on Mr. Alexander's stuff, is that correct?
Once I.
Yeah. All right, about it, okay.
He charged me the south first.
Okay, Knox County, can you turn the microphone on there? Knox County, can you turn the microphone on? See that little red microphone looking thing there, Mr. Slade? If you push that, it'll come on. If you kind of tap on the window there and get somebody and come and help you, it'd be a good thing. There it is. There we got it. Can you hear me now, Mr. Slavy? Say something, Mr. Slavy. No, still can't hear you.
How about now?
Now we got it. Now we got it. So much. Commonwealth versus Christopher Slavy, 22 CR 0029. Are you Christopher Slavy?
I am, yes, sir.
Born in 1980.
1980, yeah.
Last four digits, social security number 7224.
Yes, sir.
We're here on a probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Slavy's on 12-month misdemeanor sentence. He got new charges in Macquarie County, criminal abuse first and wanton endangerment first. And my understanding is he's going to stipulate to the revocation.
Going to stipulate?
That is correct, Judge.
Okay, you wish to stipulate, Mr. Slavy, on the violation of your probation?
I guess so, yes, sir.
Okay, well, I'll go ahead and revoke your probation and then they'll take your thing up there in Knox County, I would assume, and try to work the whole thing out for you, okay? Okay, thank you very much, Knox County Detention. Thank you for your cooperation. You're excused. Let's go to Adair County now. And y'all can just use it, Knox County. There you go. Adair County, Tiffany Bell. Are you Tiffany Bell?
Yeah.
Were you born, this is 23 CR 0071 that we're here on. Were you born in 1986, Miss Bell?
Yeah.
And the last four digits is social security number 0422. Is that correct?
Yeah.
Okay, we're here on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, Ms. Bell has a 3-year sentence on possession of controlled substance first degree. She met with Mr. Murphy on November the 22nd, 2023 to do a case plan. After that, she wouldn't show up. She wouldn't call. Mr. Murphy didn't have any more contact with her. And basically, we had to file the motion that she was terminated then from drug court because of non-compliance.
Okay, y'all want to stipulate?
Judge, the one caveat to that is I will say Miss Bell, and she can testify to this, did go to rehabilitation on her own. She was actually not in Burkesville. She was in Albany and then went to rehabilitation in Cumberland, or excuse me, Corbin, Kentucky, on or about the times they were trying to contact her. You know, Judge, but before we get to revocation, we would just ask for her to actually be given a chance to start drug court.
She's already been given a chance, and what I'll take a look when I after I see the pre-sentence investigation report, we'll see what's the best resolution for it. She might need to be on drug court or something like that, but I'm not going to go through this game plan on the pretrial diversion thing.
I understand, Judge.
So I'm going to revoke the pretrial diversion because she absconded and that sort of thing. And so then we'll order pre-sentence investigation report and have her sentenced on March 19th. And at that juncture, we'll see what modality would be the best thing to deal with her in, okay?
And Judge, if we could, and I'll certainly discuss this with the Commonwealth, with the court mind setting this, scheduling this also for negotiation on March 8th.
That'd be fine.
Thank you, Judge.
It'd be good. Your attorney will come talk to you. They're gonna do a negotiation day on the 8th. Is that what it was?
Yes, Judge.
At 1 p.m. Okay, thank you. David Brinker. Commonwealth versus David Brinker.
Yes, sir.
Okay, are you David Brinker?
Yes, sir.
We're on 23 CR 0067. Were you born in 1965, Mr. Brinker?
65, yes.
And last four digits, social security number 2619.
Yes, sir.
Yeah, now you don't have an attorney listed here. Do you have a private attorney before I do the arraignment?
No, sir. I had a female.
You had a court-appointed attorney?
I didn't recognize him. I didn't know if this was for my time.
I'll continue DPA's representation when there is a DPA lawyer here. You're here for the purpose of arraignment. Mr. Pennington, say something so he can see you, the voice activated.
Good morning.
Okay, there.
Hello?
Yes, sir.
Okay, okay. You have a right to remain silent, Mr. Brinker. If you have any questions, I'll have your attorney get in contact with you. The grand jury of Cumberland County has returned a indictment of possession of methamphetamine, first degree, and possession of drug paraphernalia. There you go. Counselor, do you acknowledge the identity of Mr. Brinker, receive indictment, waive formal reading and arraignment, and plead not guilty?
Yes, Your Honor.
Mr. Brinker, I have signed a reciprocal discovery order here that requires the Commonwealth to give you all the information they have to prepare for defense. What's this gentleman's bond?
No bond currently.
Why is that? Look at it.
That was, what you said it
I know what I said, but I want to be reminded why. Mr. Stockton, you know anything about this case? I'm going to read it up, if you will.
I know we've had an NCIC, Your Honor, since September of last year.
Well, that's why it
He was
is.
indicted in July and just got served
Yeah.
later.
I guess if y'all interviewed him, what do you find out?
You a moderate, he was a moderate. It's transported in Indiana.
It's extradited. Well, I want you to get an opportunity to talk to this gentleman before I make any modification. If you want a modification of his bond, since he was an NCIC, you'll need to come up with some explanation as to where he was, why we had to go get him, and then you can contact the Commonwealth to take a look at that, okay?
Yes, Judge.
Okay, we'll schedule this for a negotiation day on the 8th, 1 p.m., and the next court date's on the 19th.
I'll be able to speak to you soon, David.
Okay.
Okay, thank you very much. Stacy Daniels. Commonwealth versus Stacy Daniels. Commonwealth versus Stacy Daniels, 23 CR 00114. Are you Stacy Daniels?
Yes, sir.
You were born in 1987.
Yes, sir.
Last 4 digits social security number 1197. We're here for a pre-trial conference. What does the Commonwealth have to say?
We have a plea, Your Honor.
Is it
Pre-trial
felony or a conversion?
I see what you're saying.
Thought that was down, is that it was 3 to 5.
That's correct.
Okay.
Yeah. Well,
Well, it's just a three on both charges. But then we see both charges are running concurrently over here. Pre-trial diverted for 5 years. It's a misdemeanor and a possession.
yeah, I did the same, but it's correct. Okay. Okay.
Okay, Ms. Daniels has identified herself here. What does the Commonwealth have to say?
We have a pretrial diversion plea, Your Honor.
Okay, Ms. Daniels, a motion has been tendered that says you wish to enter plea today. Is that correct? You need to speak up.
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Was it freely and voluntarily given?
Yes.
Are you the same person that was identified in 23 CR 00114?
Yes, sir.
Is your judgment impaired today in any way?
Sir.
Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes, sir.
You view the evidence the Commonwealth has against you.
I'm sorry. Can you repeat that?
Have you reviewed the evidence the Commonwealth has against you? You
Yes,
you're
sir.
fully informed about your case?
Yes, yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm gonna go down through those rights and then ask you if you waive them. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented by counsel at jury trial, right to confront and cross-examine all witnesses called against you. You have the right to produce evidence, right to call witnesses, your favorite process issue, appellate attendance. You have a right to appeal this matter to higher court if you lose, and have a right to require the Commonwealth prove beyond a reasonable doubt that you guilty charged against you. Understand that by entering a guilty plea today, you give up those charges. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I do not have to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation to decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. I'm going to ask some qualifying questions as far as a pretrial diversion. Have you previously been diverted in the last 5 years?
No, sir.
Do you have any felonies in the last 10 years?
No, sir.
I'm currently on probation or parole.
No, sir.
You understand that if you fully complete the diversion program, the charges will be dismissed pre-trial diversion, and you have your record expunged. Do you understand that?
Yes, sir.
You understand that if you do not successfully complete the program, you brought before the court and I avoid your pre-trial diversion, I'll schedule a sentencing hearing. You'll be a convicted felon, and any future convictions you have could be enhanced under the persistent felony criminal law. Do you understand that?
Yes, sir.
Mr. Stockton, who's going to present the Commonwealth's representative? Listen closely, man, to see if this is what you read.
Your Honor, upon a plea of guilty possession of controlled substance, first degree, the defendant receive a sentence of 3 years. On a plea of guilty endangering welfare of a minor shall receive a sentence of 12 months. Those two shall run concurrently for a total of 3 years. Pretrial diverted for 5 years. Diversions be supervised. She'll enroll and complete the Cumberland County Specialty Court Program, pay court costs at discretion of the court, maintain gainful employment, or do 30 hours community service a week. All evidence in this case will be destroyed. Court costs discretion of the court.
Is that what you agreed to, ma'am?
Yes, sir.
Are you pleading guilty because you are guilty of the acts charged in the indictment?
Yes, sir.
And so your own free will.
Yes, sir.
One of your constitutional rights is still your desire to give up those rights by entering this guilty plea and allow the court to fix your punishment according to law.
Yes, sir.
Okay, Mr. Bailiff, will you recover the signature here, bring it up here to me? Thank you very much. Ma'am, is that your signature on that document there?
Yes, sir.
I will accept the plea, sign the diversion order. You'll need to meet the probation and parole officer. Does she have to serve any additional time?
Judge, I think the plea is set up that she would get out of orientation of specialty court, which hasn't happened.
Okay, is that right, Mr. Stockton?
Yes.
Okay, she get out, so the probation and parole officer will be up to the jail in the city, okay?
She wants $250.
Do what?
$250.
Okay, it's $250. I'm gonna wait till you finish drug court. Then you can pay, after you finish drug court, you can pay it $30 a month, okay?
Sir, thank you.
$150. Okay, thank you very much. Cecily Davis. Cecily Davis.
Hello.
How do you say your first name, Miss Davis?
You said it correctly. It's Cecily.
Thank you. Commonwealth versus Cecily Davis, 23 CR 0070. You are Cecily Davis. You were born in 1994, is that correct?
Yes, sir.
In the last 4 digits, your social security number 3327. You're here for the free trial conference. What do we have?
Guess we need to set a trial. She's maintained her innocence, and I'm curious if she's guilty myself. So,
Well, what is she charged with?
charged with theft of an automobile. She's claimed that we've provided forged evidence and everything, so I want to see if that's right or not.
Okay, I'll get mine.
I've not had any inclination she wants to enter a plea, so.
How many do you have any out-of-state witnesses or anything?
I don't think so, Your Honor. This should be.
Judge, I understand Miss Davis is in custody.
Please speak up.
I understand Miss Davis is in custody. I would ask for a little bit of time on trial. My understanding, there's also a case related to this matter out of Tennessee where charges were dismissed, so I'll need to. I've reached out to Miss Davis's prior attorney, but no luck.
Who is her prior attorney?
Miss Davis, what's his name again?
Doug Crawford. He's only licensed in Tennessee, Pennington.
That's all, Miss Davis.
What about April 30th?
It's fine for Commonwealth.
There's a conflict on the 30th and we have a trial May 1st scheduled. Now, Judge, for being honest, I do not expect that trial to go
What trial, the 30th?
on the 1st.
Well, I've got another trial scheduled. Is that you?
That's me.
Thank Chris, you want that? He can go in there and play. You want to set this one on the first?
We can.
Yeah. May the 1st.
Yes. Is Christian set for three trial this month?
When they do an agree order.
Okay.
Well, now, May the 1st is on a Wednesday here.
Okay.
April 30th. On Tuesday.
What about Monday?
Do what?
I didn't know, Mr. Pendon
He
says he
checked
has
that.
a
Yeah,
conflict on the
I
30th.
can't do, Judge, I could do the 29th.
'29th.
Okay.
Now, I guess between now and then you'll contact the prosecutor. Is this the same vehicle? Is it-
Well, the law is clear that if you can have a receiving and a stolen property case in two different states, and there's no double jeopardy.
I'm not
But-
suggesting that it's not that. I was just suggesting if there was some reason it was dismissed down there.
I don't know, maybe I don't know why. I know we've been in contact with the victim here and she wants something done on the case.
Okay. Okay, we got to have a trial date scheduled, and I guess we have a pre-trial on March the 19th. Is that correct? You want one?
You can get that.
Judge, I'll be following that. I tried to reach a resolution with Commonwealth with regards to bond, much like Mr. Brinkley. Ms. Davis was initially put in NCIC, so her bond is artificially higher than one would say it should be.
It's not artificial. I did it.
But she's got a quick trial date.
People get brought with NCIC, and they don't come back. Sit it till they can make a bond. What is the bond sit at now? $50,000. What kind of bond can she make?
Judge, she has family that can make surety or not that
They're out
much
of state.
property, but
They're out of state. She have anybody?
No, I have family in Kentucky.
You will.
Ms. Davis, let me talk. Judge,
Yes, sir.
Or here in Cumberland County.
Well, I wouldn't have any problem with a $50,000.
Property bond.
Yeah, $25,000 property bond. It takes $50,000 worth of unencumbered property. I don't have any problem with that. Changing her bond. Now, she'll have
No contact with the victim in this case.
no contact with the victim, and you also will need to sign a waiver of extradition where you agree to come back to the state. She's a Tennessee resident. So you got one of those waiver of extradition? Okay, we'll sign one of those. In other words, I'm gonna change your bond, ma'am. If you got any family in Kentucky with $25,000 property, they can sign that bond. The property that they have will have to be worth 50,000 unencumbered, and then you can sign a waiver of extradition that we'll send up to the jail to you, where you agree to come back to Kentucky to face the charges. Will you agree to come back to Kentucky and face the charges?
Yes, sir.
Okay, well, we'll send that up to you then.
Thank you, Judge.
Thank you so much.
Thank you.
Would you like?
Standard conditions. Maybe she stay out of the state of Kentucky. I don't think she'd be wanting to come up here for vacay anyway. Anna Gail Harley. Anna Gail Harley. Commonwealth versus Anna Gail Harley. Are you Anna Gail Harley?
Yes, sir.
You're here on 22 CR 0092 for sentencing. Were you born in 1999?
Yes.
Last four digits, social security number 3238. Yeah. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole? Have you had an opportunity to look at the pre-sentence investigation report done by probation parole man? Hello?
Me?
Yeah, you.
Yes.
It's your time on the stage, Abigail Harvey. Okay, have you looked at this pre-sentence investigation report done by probation and parole? Mr. Cross?
We sent it to you, we sent it to the jail when we got it, Miss Harley. Did they give it to you?
No, I just filled one out, actually. I didn't look at any results of it.
Can't hear her. What did
She said she hadn't seen it.
But we want to, just email it back up there too, because when we get them, we send them direct. And
Well, yeah, but after you send them direct, you need to contact your clients, see if they've read them and go over it with them. You're responsible for going over it with her.
Well, if court will allow us them all, we'll send it back up there. Thank you.
We'll be back to you, Miss Harley, okay? Will you check with the jail there, ask somebody if they've received a pre-sentence investigation report sent by the lawyer for you to review?
Yes, sir.
Okay, and then we'll come back to you. I won't forget you.
Check the email for
Billy Huddleston.
facts over.
Billy Huddleston.
I didn't finish with her.
Yes, sir.
Okay, are you Billy Huddleston?
Yes, Your Honor.
23 CR 00101. We're here for sentencing. Mr. Huddleston, were you born in 1962? Are you there, Mr. Huddleston?
Yes, sir.
Were you born in 1962?
Yes, Your Honor.
Last four digits, social security number 3418.
Yes, sir.
We're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
No.
Can you hear me?
Yes.
Do you remember going over that paperwork with me 2 days ago
Yes, sir. Yeah. I'm sorry.
about your sentence?
Yes, sir.
Judge, we went over his PSI. I think you may be confused on what you were talking about.
Yes, I was.
The information in that paperwork substantially correct? Is it correct?
Yes, ma'am. Yes, sir.
Okay. Is there any reason this gentleman should not be sentenced today?
No, Your Honor.
Upon a plea of guilty possession of firearm by a convicted felon, the defendant shall receive a 1-year sentence to serve. Is that correct?
That
Yes, Your
is,
Honor. Yes, sir.
Judge, I don't want to say correction, but I would ask if probation and parole could check on the custody credit that Mr. Huddleston has. He says that he was on home incarceration and that wasn't reflected on the PSI.
Okay, I'd be glad to give him credit for that. What's the court cost? Huh?
$250.
$215 court costs. When you get out of jail, make your first $30 payment 30 days after you get out of jail. That'll let you get back on your feet a little bit, Mr. Holston, okay?
Yes, sir.
Pay it $30 every month and $215 is paid.
Yes,
And they're
sir.
gonna check, make sure you get credit for your ankle monitor, okay?
All right, thank you, sir.
You got Kenny Huddleston. Commonwealth versus Kenny Huddleston. 23 CR 00113, and that's for the pretrial conference, and 18 CR 00016 for probation revocation. Mr. Huddleston, were you born in 1990?
Yes, sir.
Last
Yes.
four digits social security number. Last four digits social security number 9589.
Yes, sir.
You know, what does Commonwealth have to say in this case?
We have a felony plea, Your Honor.
Okay. Mr. Huddleston, a motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Currently under the influence of drugs or alcohol?
No, sir.
Freely and voluntarily given?
Yeah.
Are you the same person we identified in the two cases, 23 CR 00113 and 18 CR 00116? You the same person?
Yes, sir.
Okay, have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Your judgment prepared today in either way. You know what's going on? Are you impaired? You understand what we're saying and talking about?
Yeah.
Okay. You believe you have certain rights under the Kentucky and United States Constitution. You do not have to enter a guilty plea today. Before I can accept, I need to go over these rights, and at the end, I'll ask you if you understand it, okay? You have a right not to testify against yourself. No one can make you say anything. Your right to speak, or I'll be jury, right to be represented by counsel at the jury trial, the right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right for the Commonwealth to prove beyond a reasonable doubt that you are guilty and charged. You understand by entering your guilty plea today, you give up those rights. Do you understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by the law. I don't have to accept the recommendation. Prior to accepting any recommendation, I will await a pre-sentence investigation or done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation?
Upon a plea of guilty to fleeing or evading police, first degree, the defendant shall receive a sentence of 1 year, probated for 3 years. Probation is to be supervised. The defendant agrees to enroll and complete the Cumberland County Specialty Court or Specialty Program. The defendant shall pay court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky, and the defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Is that your understanding of the agreement, sir?
Yes, sir.
Now, are you pleading guilty because you committed acts charged in the indictment? Is that why you're pleading guilty?
Yes.
Okay, knowing your constitutional rights, is it still your desire to give up those rights, enter a guilty plea, and allow the court to fix your punishment?
Yes.
You understand if entering a plea of guilty to this charge, any future convictions will be enhanced as far as the penalty because of this plea. Is that correct? Mr. Bailiff, will you recover so this gentleman, do you understand that any future felonies could be enhanced? Did you say yes?
Yes, sir.
Now is that your signature on there? So you can hold that back there so you can see that right there? Is that your signature?
Yes, sir.
I'll accept a plea order, pre-sentence investigation report to be done by probation and parole schedule of sentencing on March the 19th. Okay, thank you very much. Kelsey Jones. Kelsey Jones. Raymond. Commonwealth versus Kelsey Jones, 24 CR 0003. Are you Kelsey Jones?
Yes, sir.
Were you born in 2001?
Sir.
What year were you born?
2001.
The last four digits social security number is 7057.
Yes, sir.
You're here today for the purpose of arraignment. It appears Mr. Poindexter's entered an appearance. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with incest. Do you understand what that charge is?
Yes, sir.
Okay, Mr. Poindexter, you acknowledge the identity your client received after the way formal reading and arraignment inter plea of not guilty, reserving all pretrial motions.
I do, Your Honor.
Okay, I am signing a reciprocal discovery order. Requires the Commonwealth to give you all the evidence that they have in your case. I will set a negotiation day for March the 8th and the next court date for March the 19th. What is this lady's bond?
$50,000 cash.
What's the story here, Mr. Stock? As far as cash.
Allegedly, her and her husband had sexual relations with this lady's younger sister who was 14.
Stepsister.
Stepsister. I guess that's a distinction.
And it is under the law. We don't think it's going to meet the statute, Your Honor.
Later. I just know what the KSP says. So.
Yeah. Of course, it
Proves
could still be
otherwise.
charged as a complicitous, a sex act.
Yes, sir.
So you might need to take a look at that.
Yeah, I don't know. I thought she was also, she's not charged with the rape third, just the incest.
Said incest.
I
No,
thought she had.
Yes,
both
sir. It
charges.
just says incest.
I'll look and see. I know he's charged with both. With
yeah, well, what do you want to do about the bond considered a charge?
Well, her husband's out on bond, so. He was arraigned earlier.
Can we do a surety with an ankle monitor?
Nobody's made that offer.
I'm gonna change her bond to a surety bond. $15,000 surety bond,
Thank you, Your Honor.
considering the charge, you know. And clerk approved surety, but she stay away from the victim and be under the normal conditions. She could be at home, church, work, or the doctor. Okay, and maybe to see her lawyer.
Yes, Your Honor.
Okay,
Yes, Your Honor. Thank you.
okay,
Judge, that's all I have. Can I be excused?
absolutely.
Thank you, sir.
Brian Muse, that we've lowered your bond. Somebody in your family, ma'am, can come up and make your bond. Brian Muse. Are you Brian Muse?
Yes, sir.
You born in 1981.
Yes, sir.
Last four digits, social security number 9937.
Yes, sir.
You're here today in 23 CR 0037 for a pretrial conference. You're represented by Ken Garrett. What's the Commonwealth have to say?
We have to believe, Your Honor.
Is it felony or diversion?
Felony.
Mr. Muse, a motion has been tendered. It says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Plead freely and voluntarily guilty.
Yes, sir.
The same individual that we identified a second or two ago in 23 CR 0057.
Yes, sir.
Is your judgment impaired today in any way?
Sure.
Have you discussed the charges with your attorney?
Yes, sir.
Are you satisfied with his advice?
Yes.
You reviewed the evidence the Commonwealth has against you.
Yes, sir.
You believe that you've been fully informed about this case. You believe you've been fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I
Yes,
can, I need to know that you understand those rights. So I'm going to go down through your rights at the end to ask if you understand them, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter higher court if you lose. Right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand by entering a guilty plea today, you give up those rights. Do you understand that?
Yes.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation report from probation and parole. In the event I did not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Do you understand this? And Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Okay. Upon a plea of guilty to possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years, probated for 5 years. Probation is to be supervised. The defendant shall receive credit for time served, 55 days. The defendant shall pay a fine of $200. The defendant shall pay a tow bill of $175 and a storage bill of $500 for a total of $675 to the Cumberland County Sheriff's Department General Fund on the 2000 Chevy Cavalier, VIN number 1G1JC12440T7243495, to be released to the defendant. The defendant agrees to be assessed by the social services clinician and will follow any recommendations. The defendant shall pay a fine and court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the law of the Commonwealth of Kentucky and shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Okay, go over the exact charges again, please.
Yes, so the ones that he's being sentenced to, or the initial?
Well, I'm not sentenced yet.
Okay, the plea of guilty is to possession of a controlled substance, first degree. He was originally charged with trafficking in a controlled substance, first
I didn't
degree.
know if there was a DUI involved.
No, Your Honor.
Okay. Do you understand those charges, sir, that what she is that what you agreed to?
Yes, sir.
I'll order a pre-sentence investigation report done by probation and parole and schedule your sentencing on the 19th of March.
Judge, we would ask that he be released until that time. I don't think the Commonwealth's gonna have an objection to it. It will be a probated plea.
Yeah, that's great.
That'd be fine.
2 months in.
Okay. You want to bring your signature up here?
Yes,
Your
Judge.
signature. You're to bail.
And Judge, can we just do an oral on?
Well, I just thought you signed that if you want.
The rules wouldn't let me
You
do.
didn't take him home,
The
stop at
rules-
Arby's or something. Why just give me a second to look at this? Is that your signature right there, sir?
Yes, sir.
What do you have to say about the bond, Mr. Stockton? You want a $15,000 surety bond, clerk please.
It's fine. That's what it already is.
It's already there? Well, I'll just let him out on that bond.
Yeah, his family's from Tennessee, and so he didn't know anybody that could sign.
Well, who signed the surety bond?
It's said it, no one's.
No one ever did.
Because he doesn't have people in Kentucky.
Okay. Well, I want him to sign a waiver of extradition. You raise your right hand, you swear and affirm that you will, raise your right hand, sir. Swear and affirm that you will return to Kentucky to face these charges.
Yes, sir.
Yeah, he never did.
Do what?
I thought he was a Byron.
Yeah. He lives close by, Judge, but his family, anybody who could post a bond for him lives in Tennessee.
He's actually arrested.
Where? He's got a Glasgow address. You got nobody over there to sign a $10,000 surety?
No, sir.
No family there.
Mr. Garrett sure would post a $500 cash bond.
How about a $500 cash bond?
Ryan, were you able to hear that?
Can you make a
Yeah,
$500?
I don't have access to my money. I mean, I can pay the $500 if I get out. I just can't pay it
sitting in here
Where is your money?
in the bank.
What bank is it?
State bank. I mean, I have cash around the house and stuff. I don't have nobody to come get me. Half the people don't even know where they're gonna get it.
You can pay some $500 to
I don't think the ethics rules would let me do that.
That is a problem. I just want to check to see if you're gonna do it.
Yeah.
I
Your
tell you
Honor,
what, I'm gonna allow you to get out and you bring a $500 bond and post it. Oh, you can take it over there to the Barron County Clerk's office. They can take a bond over there.
I can do that today.
Yeah, I'm gonna let you out today. You got your dates from your lawyer. You be back over here. We'll get you for absconding. You understand what I'm saying?
Yes, sir.
Okay, thank you very much.
Thank you.
Citizen on the 19th. Kenneth Neal. Commonwealth versus Kenneth Neal. Close of business today. Ken?
Yes, sir.
Well, let's send him over, let him out. He needs to have that bond over there for the close of business today, okay?
Okay, I will, I'll call him at the jail and let him know.
Okay. Kenneth Neal, are you
Yes.
Kenneth Neal?
I'm him.
Okay, were you born in 1978, Mr. Neal?
I was.
Last four digits of your social security number 4427, sir?
It is.
Okay, you're here today on a pretrial conference. You're represented by Mr. Pennington. What does the Commonwealth have to say in this case?
We have a
You need to
felony.
get up to the microphone.
We've got a felony plea, Your Honor.
Yeah, felony plea. Mr. Neal, let me scoot up here where you can hear me, all right? A motion's been tendered, says you wish to enter a plea today. Is that correct?
That's correct.
Are you currently under the influence of drugs or alcohol?
No,
Is this plea freely and voluntarily given, sir?
freely and voluntarily.
Okay, are you the same person that we just identified a minute or two ago in 23 CR 0025?
Him,
Is your judgment impaired today?
none whatsoever.
Okay, have you discussed this matter with your attorney and you're satisfied with his advice?
Yeah, I'm tickled.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes,
You understand that you do not have to enter a guilty plea today. You have certain rights on the Kentucky United States Constitution. I need to know that you fully understand your rights.
I do.
Okay, and I'll ask you after I go over here. I'm sure you do, but I just have to do this.
All right.
Okay. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses, call testify against you. Right to produce evidence, right to call witnesses in your favor, right to fill this matter to higher court if you lose. Right to require the Commonwealth to prove on a reasonable doubt that you're guilty charge against you. Understand that by entering this plea today, you give up all this.
I do.
Okay, now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence for I don't have to accept the recommendation. Prior to accepting the recommendation, I will order a pre-sentence investigation report done by probation and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 1 1/2 years to serve. The Commonwealth will oppose probation. This sentence is to run concurrently with the Wayne Circuit Court case number 23 CR 153. The defendant shall pay court costs at the discretion of the court. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky, and the defendant shall remain on active supervision until any and all fines and court costs are paid in full until further request of probation and parole.
You know, are you pleading guilty because you did commit the acts charged in the indictment, sir?
I did. I committed it.
Okay, knowing your constitutional rights, that I've explained to you, still your desire to go ahead and enter a plea and let the court fix your punishment.
Guilty, yes.
You understand that any future felony convictions could be enhanced as far as the sentence because of this plea.
Yes.
Could you bring the document up here and let me show this gentleman his signature?
And Judge, as a point of order, I'm not sure, and I checked with Mr. Officer Garner. Mr. Neal was sentenced or pled guilty in Bourbon Circuit Court. So I was just trying to inquire if the court, or if there's this is supplemental. Okay, never mind.
Okay, is this your signature on there, sir?
It is.
Okay. Yeah, I accept the plea. Now, has he been a state prisoner? Can we waive the pre-sentence investigation? Okay, we'll need a pre-sentence investigation report done by probation parole and schedule a sentencing.
I did pre-sentence investigation.
Well, they'll just do a supplemental, so it won't take as long. They'll do one from the time the last one is, so we'll schedule on the 19th, okay? Okay.
Be back in 3 weeks, Ken.
All right.
Thank you very much. Okay, Raymond Oliver.
I'm done.
Raymond Oliver. Ms. Costello.
Yes, Your Honor.
Commonwealth versus Raymond Oliver.
Yes, sir.
Are you Raymond Oliver?
Yes, sir.
22 CR 00108. Mr. Oliver, you born in 1969?
Yes, sir.
Last 4 digits, social security number 1975.
Yes, sir.
Okay, what does the Commonwealth have in 22
Yeah.
00108?
Case is pending. We got the DNA back. We still need to request a serological on any type of fluids that was recovered. And then we're waiting on a phone of Mr. Oliver's that was sent from the electronic crimes branch. Ms. Costello and I were discussing whether to set a trial date maybe in the summer, so we might get those records sooner.
Yes, it's been pending a while, Your Honor, and Mr. Stockton doesn't have it. It's not that, the Commonwealth could give them if they had. But we're hoping maybe if we set a trial date, that would encourage the lab, since it's been over a year, that maybe could hurry, just.
What's the charge on this?
This is the rape and sodomy case with multiple counts.
I think we ought to set a trial date if he's been held over a year.
Yeah, I think
Yes, Your Honor,
so,
we've
too.
been waiting. The DNA came back last month, and we were hoping the phone dump would come back too.
But if I've got a
Phone
trial,
what?
That they collected his phone, and I think maybe her phone as well into evidence. I think maybe there's 2 phones, and we're still waiting on the extraction report from those, and we've been waiting. I mean, they were taken in district court when he was arrested, Your Honor. Mr. Stockton doesn't have them. We, of course, don't have
I
them.
think if we have a trial date, I can send them a letter and we'll get that.
That's kind of what we're hoping for. Your Honor, I don't know if it fits the court or Mr. Stockton's schedule, but in July, I have nothing scheduled at all the week of July 15th.
That's fine. I was gonna suggest, since we can move Bricker, would you want to use that date, the 10th and 11th of June? Between we set him to the 25th and 26th.
June 10th and 11th.
I could do that. I'd set Mr. Bricker over a case today, but I'd already had somebody on tap to do that, so I'm fine with that as well. I do just want to say, with the caveat that we do need these records for the trial. Hopefully this will,
I like
the next 30 days.
yeah, hopefully it'll spur the lab on.
On June 10th.
Yeah, it's a main deal.
Can you do this in one day?
I think the jury instructions will take us a day.
Yeah.
Sorry.
We go late tonight on this. I don't have that many witnesses.
Well, let's do it on the 11th.
Okay.
Well, let's schedule it for 10th and the 11th. If they don't have any jury trials that day, we'll just do it on the 10th. If they do, we'll start on the 11th.
Okay.
And then we'll be done with jury selection, everything, and we can move to the downstairs courtroom for the 12th. but without interfering with the district court.
Right.
That is it for me, if I could be excused.
Well, congratulations. Okay, Mr. Oliver, your attorney will be up to see. She got you a trial date scheduled now. They've got some information from cell phones that they got to
Yes,
get
sir.
before she can finish. So she'll be up to see you. Okay, thank you.
Thank you.
And Raymond, as soon as I get anything.
Jamie Posey,
I'll send-
Jamie Posey. Come up versus Jamie Posey. Are you Jamie Posey?
Yes, sir.
You born in 1977?
Yes.
Last four digits, social security number 6855.
Yes, sir.
This is 23 CR 00115. We're here on a pretrial conference. What do we have?
That diversion, please, Your Honor.
Ms. Posey, a motion has been tendered, says you wish to enter a plea today. Is that correct?
Yeah.
Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is this freely and voluntarily given?
Yes.
Are you the same person that we identified just a couple of seconds ago in 23 CR 00115? Are you that same person?
Yes.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you, believe you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky United States Constitution. Before I put the plea, I need to know that you understand those rights and go over it, okay? You have a right not to testify against yourself. No one can make say anything, right to speak trial, but jury right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, and have a process issue to compel their attendance. You have a right to appeal this matter to higher court if you lose, and the right to part of the Commonwealth proving on a reasonable doubt that you're guilty. You understand by entering the plea today, you give up those rights. You know, I may consider the Commonwealth's recommendation that I may enter a applying range of sentence provided by law. In the event that I do not accept the recommendation and try to apply a higher sentence, you have the right to withdraw your plea and go to trial. Do you understand it? Now, I'm going to ask you some qualifying questions. Have you been previously diverted in the last 5 years?
No, sir.
Okay, have any felonies in the past 10 years? Okay, are you currently on probation? You understand that if you successfully complete the diversion program, the charges will be dismissed and you can have your record expunged. Do you understand that? But if you do not successfully complete and I revoke your pretrial diversion, I'll have a pre-sentence investigation report. You'll be sentenced as a felon and this can be used against you in future felony convictions. You understand that?
Yes, sir.
Ms. Gordon Anderson, will you be real loud here and explain what, and ma'am, listen to see if this is what you agreed to.
Upon a plea of guilty to possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years, serve 60 days, balance pretrial diverted for 5 years. Diversion is to be supervised. The defendant agrees to be assessed by the social services clinician and will follow any recommendations. The defendant shall pay court costs in the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Is that your understanding of Commonwealth's recommendation, ma'am? Is that what you understand the Commonwealth recommended?
Yes, sir.
And Judge, if I may just add one thing, and I think that might have been Miss Hosey's hesitation. Judge, I'm showing that Miss Posey was booked in the Adair County Detention Center on 1/4/24. Discussed this with the Commonwealth, and as of today, she's hitting at about 56 days credit instead of 60. They've agreed if the court would be inclined to give her credit for time served, she could get out today.
That's fine.
That's fine.
Thank you, Judge.
Are you pleading guilty because you did commit the acts charged in the indictment, ma'am?
Yes, sir.
And so your own free will?
Yes, sir.
Y'all will bring this, knowing constitutional rights to your desire about be proceeding, fix your punishment. Let me see, your signature so I can get. Ma'am, is that your signature on there?
Yes, sir.
Okay, well, I'll accept the pretrial diversion. When did she meet with the
That'll
probation?
be Monday, Your Honor.
Okay, you'll need to go at 9 a.m. on Monday morning, be at the probation and parole office in Columbia for them to scope the terms of this, okay? Your
Okay.
court costs are how much?
$250.
215? Okay, and you'll need some time to pay the 215. I'll let you pay it $30 a month, and the first payment will be 30 days from today. So you can get there at 9 a.m. to go over the conditions, and we'll let you out today on your own recognizance, okay?
All right, I'll be there, Your Honor.
Okay, thank you.
Thank you, Judge.
Yeah. Okay, let me just get down through this. Jesse Randolph. Jesse Randolph. How about this? Jesse Randolph, 23 CR 0087. Are you Jesse Randolph?
Yes, sir.
Born in 1981.
Yes, sir.
Last 4 digits, social security number 2641.
Yes, sir.
You're on a probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Randolph has a 7.5 year sentence, and there was an altercation in his house where he wouldn't come out and with the deputies, and he threatened to do harm to himself, and also he tested positive for methamphetamines.
And Judge, I've discussed this case with the Commonwealth. I think we're in agreement for a evaluation for Mr. Randolph, given some of the allegations, what's going on, even.
KCPC evaluation, yes.
Okay, Mr. Randolph, I'm not gonna revoke you today. I'm gonna give him a chance to do an evaluation on it, see if you've got some issues going on, okay? So your attorney will be up to see you, and we'll schedule it as soon as we can get the evaluation done.
I'll be able to talk to you, Jesse.
Okay.
Thank you. John Scott. John Scott.
Yes, sir.
Commonwealth versus John Scott, 23 CR 0045. Are you John Scott?
Yes, sir.
1962.
Yes, sir.
That's 4 digits, social security number 9063. We're here on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, Mr. Scott has 3 years on a possession charge here in Kentucky. On 12/26/23, he got a new charge in Tennessee, a possession of methamphetamine, which was a Class B felony down in Tennessee. And under the interstate compact, they're requesting revocation.
Judge, we'll stipulate, I've discussed this case with Mr. Stock, and if we could have that 3/8 for negotiation and let Mr. Scott be sentenced on the 19th.
What now?
If we could have the 3/8 date for negotiation and sentencing.
What kind of negotiation date? It's already. It's a pretrial diversion.
It is,
So
Judge.
I'm gonna go ahead and revoke the pretrial diversion. And then we'll schedule his sentencing on the 19th, and you can negotiate whatever you want to with Mr. Stowe. You want a negotiation day on it?
I can talk to him about, one
I
thing
can
we're
do
gonna
it
have to
at
deal
the-
with, I don't know how we can do much for Mr. Scott because he's got that pending felony in Tennessee.
That's the problem.
Yeah.
Okay, I'll schedule it to 19th, is that correct?
Yes, Judge.
Okay. He'll be up to talk to you, Mr. Scott, see if they can get this stuff in Tennessee and coordinate it some way, okay? Thank you very much. Vanessa Smith. Commonwealth versus Janessa Smith. Are you Janessa Smith?
Yes, sir.
Born in 1989. Last 4 digits, social security number 1768.
Yes, Your Honor.
Yeah, we're here in 23 CR 00109 for a pretrial conference. What does the Commonwealth have to say?
We have a diversion plea, Your Honor.
That's correct, Judge.
Motion been entered that says you wish to enter a guilty plea today. Is that correct?
Sir.
Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is plea freely and voluntarily given?
Yes, sir.
The same person named in 23 CR 00109. Is your judgment impaired today in any way?
Yes, sir.
You discuss this matter with your attorney. Are you satisfied with his advice?
Sir.
When you review the evidence the Commonwealth has against you, believe you've been fully informed about your case.
Sir.
Understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial, the jury, right to be represented to counsel at your jury trial. Right to cross-examine and confront any witnesses called to testify against you. Right to produce evidence. You have to call us witnesses with in favor, call witnesses in your favor in process issue. You have a right to appeal this matter to a higher court if you lose. Right to be part of the Commonwealth, prove on a reasonable doubt to guilty charge. You understand that? But entering guilty plea today, you give up all those rights. You understand that?
Yes, Your Honor.
Now, I may consider the Commonwealth's recommendations. I may apply any range of sentence apply to the law. I don't have to accept the recommendation. If I do not accept the recommendation of the Commonwealth, decide to impose a harsher sentence. You have the right to withdraw your plea and proceed to trial. I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No, sir.
Felonies in the last 10 years?
No, sir.
Currently on probation?
No, sir.
Understand if you complete the diversion program, the charge will be dismissed pre-trial diverted. You can have your record expunged. You understand that?
Yes, sir.
You understand if you do not successfully complete the diversion program, you'll be brought back in front of the court. If I avoid your diversion, I'll have a sentencing hearing scheduled. And you'll be a convicted felon. You understand that? That can be used against you in future convictions. Okay, now what is the Commonwealth's recommendation?
Your Honor, she will plead guilty possession of controlled substance first degree, receive a sentence of 3 years, serve 60 days, balance the verdict for 5 years. Diversion to be supervised, be assessed by the SSC, follow all recommendations, pay court costs, discretion of the court, obtain and maintain gainful employment or do 30 hours community service a week. All evidence in this case be destroyed and pay court costs, discretion of the court.
Is that what you agreed to, Lincoln?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
If you do so of your own free will.
Sir.
Okay. Knowing constitutional rights I previously explained to still your desire to go forward and allow the court to enter a judgment, fix punishment, or range permitted by law. Is that, it can't be the signature up here. Is that your signature on there, ma'am?
Yes, sir.
I will accept the agreement, sign the diversion order. And she didn't get a drug court thing or anything?
SSC, huh?
SSC. Okay. So
And Judge, she has already served her balance of
she
60
can lay out
days.
today.
Yes,
She
Your
got
Honor.
her time.
We'll try to get the documents up there. You'll need to go up at 9 o'clock on Monday morning, meet with probation and parole office at Columbia. If you promise to do that, I'll go ahead and let you out today, okay?
In Columbia?
In
Okay.
Columbia.
All right. Yes, sir.
What?
Just $250.
Yo, $215 court costs. I'm gonna give you some time to pay. You make the first payment $30 a month, 30 days from today. Okay, I'll give you a chance to get back on your feet, okay?
All right, thank you.
Shannon Walters. Shannon Walters.
I'm here, Your Honor.
Commonwealth versus Shannon Walters, 21 CR 0062 and 21 CR 00146. Are you Shannon Walters?
Yes, Your Honor, I am.
1978.
Yes, Your Honor.
Last 4 digits, social security number 8119.
Yes, Your Honor.
We're on probation violations on 2162 and 21146. What does the Commonwealth have to say?
Your Honor, Mr. Walters has a 6-year sentence on possession and theft of unlawful taking automobile. And Miss Burton's here to testify. He was charged with promoting contraband, 2nd degree, while he was in jail. And also, he's not paid his restitution. He owes $1,900 restitution. He paid $100 in October, and that was it.
Mr. Walters, are you wanting to stipulate or do you want to have a hearing?
Well, I haven't spoken to my lawyer, so I guess have a hearing.
Judge, if we could get, and I didn't know Mr. Walters was in Adair County Detention Center until
Okay.
yesterday.
Okay, you have a right to speak to your lawyer, so we'll schedule this on March the 19th. Your lawyer will be up there to see you soon, okay?
All right, thank you, Your
And Ms. Burton will be in contact with you, a Commonwealth attorney will, if you're needed, to sit on the 19th, but I would go ahead and put that on my calendar if I were you, okay?
Thank you, Your Honor.
You, Cody Willis.
Judge, I know it shows Mr. Roby. I'm appearing for Mr. Roby this morning.
Commonwealth versus Cody Willis, pre-trial conference and an arraignment. Mr. Willis, you have a right to remain silent. We have an additional charge. We're going to bring you on evidently. You born in 1989.
Yes, sir.
That's 4 digit social security number 2394.
Yes, sir.
The additional charges against you have a right to remain silent are the 2 counts of theft of identity, which means that without consent of William Baker, you use PayPal account privately in the property, both of them. Counselor, you acknowledge the identity of Mr. Willis
Yes, Judge.
and the receipt of that will waive formal reading arraignment, interpleading not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay. Okay, we'll set a negotiation date in this case on 1 o'clock on March 8th, and the next court date's March.
We
9th.
probably just need to set a trial date, Your Honor. This was previously scheduled for trial. The new indictments came out. Mr. Roby got the case continued. Mr. Roby and I have talked about the case. I don't think there's any reason for grounds for settlement, so.
And I agree with Mr. Stockton, Judge. I had Mr. Roby's calendar.
I made Mr. Roby an offer and he never got back with me, so I'm sure there wasn't any fruitful discussions to be had.
I haven't spoken to Mr. Roby.
Yeah, I'm a little worried about this, to tell you the truth. Mr. Roby doesn't come here. He hadn't talked to this client.
Yeah.
I'm not gonna set a trial date here on this case until he talks to, and you tell Mr. Roby that he needs to go up and talk to this gentleman by Tuesday of this coming week and fully inform him of what the offer is on the table and what the situation is. And if he's not, I'm gonna hold him in contempt of court for not these people are up there in jail. They're accused of serious crimes, some of them, but they've got a right to be treated as human beings and don't need to be sitting up there wondering what's going on without somebody contacting. So your attorney will be up there to talk to you about Tuesday, sir. We'll go ahead and schedule it by the night to the 19th, and if we need to do a trial date by agreement, Mr. Stockton, we will.
Okay.
Okay, now we have Ethan Wilson. Ethan Wilson. Are you Ethan Wilson?
Yes, sir.
Okay, were you born in 2002, Mr. Wilson?
Yes, sir.
Last 4 digits of your social security number is 7254.
Yes, sir.
Okay, we're here in 23 CR 0058 for pretrial diversion recommendation. What does Commonwealth have to say?
Your Honor, he has a 3-year sentence on possession of a controlled substance, first degree. He was placed in the specialty court program. He was terminated on January 25th, 2024. He had failed 3 different drug tests on 10/28/23, 11/9/23, and 12/7/23. And under the sanction regime in specialty court, he was to do home incarceration. And when he was on home incarceration, he didn't follow directions. He just went wherever he wanted. So he was terminated.
You know, stipulate?
Yes, Judge.
You stipulate, we'll revoke the pretrial diversion and have a pre-sentence investigation report done. And the sentencing will be on March the 19th. Now, who else? We have anybody else that?
Got Mr. Smith, misdemeanor plea, Your Honor.
And Mr. Allison.
I mean, in Adair County, we have anybody else in jail? in there?
Got Miss Harley, Your Honor. We can go
Oh, yeah,
back
Ms.
to.
Harley.
Yeah. Anna Gail Harley.
I apologize, Your Honor. I was up there
Has
Monday
she,
and
have you had
didn't get
time
to
to
see her.
review it with her now?
Yes, we have.
Okay, let's go back to Miss Anna Gail Harley, 22 CR 0092 for sentencing. Ms. Harley, you previously identified yourself. Y'all got her, I got it here. I must hand it back to you.
Yes,
Yeah. Right here. Ms. Harley, you previously identified yourself? Have you had a opportunity to go over this with your attorney now?
Yes, sir.
Okay, is it substantially correct?
Your Honor, we have a couple of exceptions.
Okay, go ahead.
One's minor, the addresses of her family, they're not in Kentucky, they're primarily in North Carolina. I know her mom and dad are, her father, in fact, is present today. Regarding an alleged
Okay, well,
arrest.
now we can make sure that they give those correct addresses to probation and parole, so they will not be on the record. Okay.
Thank you. Your Honor, there's a reflection of an arrest on 2/7/23 in Cookville for possession of a controlled substance, disposition unknown. And Miss Harley has no knowledge of that whatsoever. She says she has not been arrested at any time since she's placed on probation other than this DUI that resulted in her revocation.
We don't have any record other than the DUI. That's the basis for the revocation.
Yeah.
Okay, well, we'll have probation and parole to take a look at that, and they'll order to delete it, that thing, unless they can give proof, and I'll sign an order deleting that if it's not proven, okay?
We have no other issue with the pre-sentence investigation.
Should be sentenced to 2 years.
2 years, yes, sir.
Pardon?
Yes.
You have anything to say about that?
Who, me?
Yeah, 2 years.
Oh, she's got 106 days in. She
So
won't.
she's eligible for a motion for shock probation, is what I'm saying.
Well, she's really got 130 some odd days.
Oh, I just going by the
believe.
PSI.
That's what I was going by, but I think she's got more. Your Honor, may I address probation today?
Well, I'm not going to address probation today, but I will address shock probation.
Fair enough, Your Honor.
When it comes time, And she had to serve so many days from today before she's eligible for shock probation.
Yeah, she's eligible for parole now because she's got so many days in, but she'd have to serve 30 more days before she'd be eligible for shock probation. And I doubt they would classify her within the next 35 days to parole. I doubt that would happen.
Well, she'd be better off if she gets parole than if she goes on shock probation.
Well, but that's so indefinite, Your Honor. You don't know.
Well, what I do though is if you'll file a motion for shock probation, if she doesn't make parole, she'll have a good chance of making shock probation. You
Thank you.
understand what I'm saying?
Yes, Your Honor.
Okay.
Thank you very much.
Okay, your attorney will come up and explain this to you. It would be your advantage if you do get parole. It's less restricted. But if you don't get parole, then I will, in all probability, favorably consider a motion for shock probation in 30 days. Follow what I'm saying?
I'm sorry.
I'll talk.
Yeah, he'll come up and explain.
I'll know.
Things are looking better, okay? Okay, thank you. Is there anybody else we have in the Dare County Jail?
No, that's it, Your Honor.
Okay. Okay, y'all may be excused. Now, we have anybody else here in this court here?
We have Mr. Alexander and Mr. Smith.
Okay, I'm gonna take just a quick break here. I'll be right back. Oh.
Yes. She's got Alexander and then you're out. I'll bring what you got.
I'll have to ask you again, my microphone wasn't on. Madam, four-person, 9 or more, you agreed?
Yes, sir.
Okay. Okay, well, what I'll do is I'll take a look at these. If they're presently in custody, we'll issue a summons to add these charges to any other charges they might be held on. If they're not in custody, we'll set a bond on each one of them in an amount to assure their appearance here, or if we, after we take a look at it, if we feel like they're a danger to the public or other people, will set a bond sufficient to protect the public, ensure their appearance, okay? The next day that y'all are scheduled to be in is March 19th, unless you're called back in because of insurrection or emergency. And as I frequently tell grand juries, the times we live in, who can ever tell when we're gonna have a good insurrection? There might be one any day, you know? So y'all are released to come back. All rise for the grand jury, and you may proceed out this way at the direction of the bailiff. Okay, everyone can be seated. Yes, we have Kenneth Alexander. You have him ready?
Yes, Your Honor.
And then you have Jacob Smith after that. Is that correct, Mr.? Kenneth Alexander, 23 CR 0097. You are Kenneth Alexander, you're born in 1964.
Yes.
Last four digits, social security number 6237, correct?
Yes.
Okay, are we here on a plea?
Yes, Judge.
Is this a diversion or felony?
Diversion.
Okay. A motion's been tendered, sir, that says you wish to enter a plea today. Is that correct?
Correct.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 23 CR 0097?
Yes.
Have you discussed this matter with your attorney, and are you satisfied with his advice?
Yes.
Is your mind impaired today in any way? You know what's going on?
Yeah.
Yeah. Okay, are you you said you were satisfied with the advice of the attorney, but have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about your case? Is that correct?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to higher court if you lose. You have the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Do you understand that by entering a guilty plea today, you give up all those rights? Is that correct?
Yes, sir.
Now, I may consider the Commonwealth's recommendation that I may apply any range of sentence provided below. I don't have to accept the recommendation. In the event that I do not accept the recommendation of the Commonwealth and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Now, this is a diversion, and so I'm going to ask some qualifying questions. Have you previously been diverted in the last 5 years?
Yes, sir.
Well, have you ever had a diversion like this?
Oh, no, sir.
Okay, have you had any felonies in the last 10 years?
No, sir.
Okay. Are you currently on probation or parole? Now, you understand if you fully complete the diversion agreement, your charges will be dismissed and you can get your record expunged. You understand that? But if you don't fully complete the program, you will be brought back before the court. The court could schedule a sentencing hearing in your case, and you would be a convicted felon. And if you had any felonies in the future, they can be held against you. You understand that?
Yes, sir.
What is the Commonwealth's recommendation, Mr. Gordon Anderson?
Upon a plea of guilty to assault fourth degree, the defendant shall receive a sentence of 12 months probated for 2 years. Probation is to be supervised. Upon a plea of guilty to wanton endangerment first degree, the defendant shall receive a sentence of 3 years, pretrial diverted for 3 years. Diversion is to be supervised. These two sentences are to run concurrently. The defendant agrees to have no contact with the victim, Fran Alexander. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained.
Is that what you agreed to?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes.
Doing so of your own free will. Okay, knowing your constitutional rights, still your desire to proceed, allow me to fix the punishment in the range permitted by law. Okay, is that your signature on the document there?
Yes.
Okay, I'll accept the agreement, sign the division, or was there any restitution or anything involved in this?
Not this one.
Okay, you need to meet with the probation and parole officer over there, okay? Now, Mr. Cross, you've got Mr. Smith, is that correct?
We do.
$215 he owes. You need to tell him that you need some time to pay the court costs. Pay the first payment 30 days from date, $30, and $30 every month you pay it, okay? Okay, what y'all got worked out? You got something worked out in this?
Mr. Mayor, please, Your Honor.
Commonwealth versus Jacob Smith, 23 CR 00111. Are you Jacob Smith?
Yes.
You born in 1991?
Yes, sir.
And the last 4 digits, Social Security 5078.
Yes, sir. Listen.
Okay, now, I understand there's a misdemeanor plea.
Yes, Your Honor.
A motion been tendered says you wish to enter a misdemeanor plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Are you the same person previously identified?
Sir.
In the indictment? Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney and you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you and you believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can take guilty plea, I need to know you understand those rights. You have a right not to testify against yourself, no one to make you say anything, right to speed trial by jury, right to be represented by counsel at jury trial. Right to confront and cross-examine all witnesses, called testify against you, right to produce evidence, right to call witnesses your favor, right to appeal this matter to higher court if you lose, and right to part of the Commonwealth if you want to reason without you get your charges. Against you enter a guilty plea today, you give up those rights. Now I may consider the Commonwealth's recommendation when I may apply any range of sentence provided by law. I do not have to accept it. In case I reject it, then I will allow you to withdraw your plea and proceed to trial. What is the Commonwealth's recommendation?
Upon a plea of guilty to assault fourth degree, the defendant shall receive a sentence of 12 months probated for 2 years. Probation is to be supervised. Upon a plea of guilty to criminal mischief second degree, the defendant shall receive a sentence of 12 months probated for 2 years. Probation is to be supervised. The defendant agrees to have no contact with Jessica Pitcock. The defendant agrees to pay restitution in the amount of $250 to Stephen Poindexter, payable through the Cumberland Circuit Court Clerk's Office. The defendant shall pay restitution in full within 30 days from the entry of this plea. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained.
Is that what you agreed to?
Yes, sir.
Is that your signature on the document?
Yes, sir.
Well, I accept the plea agreement. You'll need to meet with the probation and parole officer. Your judgment today. Somebody preparing a judgment on the thing, on a misdemeanor judgment.
It should be in the paper. And it's part.
Okay. Yeah, okay.
$190.
$190 in court costs. You need some time to pay that. You'll pay it today? Need some time? Okay, we can pay it today. And that'll be the court costs. It'll be finished. Is there any? When does the restitution have to be paid for? 30 days.
Instead, we'll pay the restitution today, then.
Yeah, is there anything else? Well, he can pay it anytime today or within 30 days, one of the things is. Is there anything else come before the court? Okay, if not, we'll stand. Adjourn. Mr. Stockton, y'all come up. We're gonna do diversion completion docket. Jonathan Matthew Scott, diversion completed. Is there any objection to the Commonwealth?
No, Your Honor, I think we can approve this.
It will enter in order. Okay, let's go to the show cause docket. Daniel Appleby.
Judge Henson for last month, you ordered him to pay $30 per month for court costs and $30 for restitution to the county, and he's not made a payment.
Okay, issue a bench warrant.
We'll still make restitution. Right, we'll still have a restitution for them.
Is it, wait just a second. Is it in the file?
Restitution, but if you order him to pay it. I don't think. Then I guess for transportation back.
Oh, that's.
Y'all need to prepare an order to submit it. Who needs? How much total restitution is he owe?
$1,000.
It was in the plea, but you need to set it over.
Usually I'll do the second third time.
Yeah, we'll do it.
Well, I'll give him to the 19th. Pass over. Send him an order, tell him he need to be paid in full or be here to show cause on the 19th. Alfred Casillas.
He may have more money this morning. That's what you
Okay. Carolina Foods.
She was supposed to pay $50, so she made $45 back, and she's not called back.
How much total she owe?
$1,030.
Issue a bench warrant on her and let her purge herself, paying $75. Then she can continue payments. Heather Opperman.
He was before, I think people were trying to pay $50 a month and she was not paying that.
Okay, well, is that a restitution order too?
No, it's just regular costs.
Okay, issue a warrant, and let her purge herself and paying $50. Now, I got a file back today about whether or not these bench warrants, are these bench warrants, have they all been served, or why are we not hearing more about them? Are they all served? Yeah. All the bench warrants I issued last month.
Three more.
Well, what about the rest? I'm not getting any feedback on it.
Let me see how you're supposed to. Let me see. It was sentenced.
Why are these bench warrants not entered? Why are these bench warrants not entered that I ordered last month? It's been a month. She said only 3 of them, and what's the deal?
How many were ordered?
Every one of them that I went down through the docket and ordered multiple bench warrants. How many, count them off and see how many. How many bench warrants in all? I want it on the record. We're on the record here, okay?
Yes, sir. There's 3 entered,
Yeah, but how many did I order in?
I'll have to go back and pull it from.
I mean, are these being entered? They don't seem to be being served. Are you entering the bench warrants when I tell you to?
Yes, sir.
All of them been entered, every bench warrant.
I will just have to go back through the docket.
Well, we need to go back through the last 3 dockets and make sure that when I order a bench warrant, that they're to be issued. There's not to be any question about it. They're to be issued.
Okay.
And those people can purge themselves by complying with the bench warrant or go to jail. Because if we're not gonna do that, there's no reason for you not to have, there's no reason to have these show cause, okay?
Yes.
Is there any other matter to come before the circuit court? If not, we'll stand adjourned for the day or in recess, I guess, until 1 o'clock. Thank you very much. Everyone have a seat. Good. Go to the child support docket. What did they say? It's Wayne Nelson's. Before we start today, I would like for us to do a moment of silence for former Deputy Circuit Clerk Wayne Melton. He served for 24 years, 25 years or something. He never was in this building, but he gave long service. So if everybody kind of bow their head for a moment of silence and remembrance of Wayne Melton. Thank you very much. Severe versus severe.
Judge asking for the June 27th date for review.
Okay. Shelton versus Shelton.
Same day for review as well, Judge.
Okay. Cash versus Roberts.
Judge, I'm tendering an order changing venue pursuant to our motion. The mother and the child both now reside in Clinton County. They're expecting that case.
Well, we appreciate that.
Take it off. Take it off.
Sent to Pulaski or somewhere.
Take it out of my hands.
Yeah. Crecilius versus Alexander.
Judge, I've got a contempt order to tender here pursuant to our motion filed February the 20th. Mr. Alexander is currently $17,000 in arrears. Tendering a contempt order, asking for some payment to be entered before March 18th, or that order be entered.
Well, this kind of crossed the line over into criminal activity, isn't it? Are you referring to?
I believe it has been.
You here?
I believe the Commonwealth's attorney is aware of it.
Yeah. Now, Mr. Alexander's got some other criminal activity charge going on, right? Did you finish that today or you have anything? Set for trial. Okay. He's ordering you to pay $500 before March 18th.
You and I had talked on the phone, right?
We've spoken several times.
I told you I had signed up some kind of paper,
Okay.
but I also.
Okay, you need Mr. Hurt, you need to move over here and you need to speak up where I can hear you there.
Yes, sir. I had spoken with Mr. Hurt and I had signed the paper. I don't know what kind of paper it was. I guess admittance of fatherhood.
Paternity?
Yeah, paternity. And I was telling him that I need, DNA if I could, because there was a lot of infidelity in that relationship.
Well, the problem is you already signed a paternity statement. Can you pull a file in? Get the file. Let's see what you've already signed. We'll pull a file, take a look at it.
And I think what Mr. Alexander is referring to, Judge, there was an acknowledgement of paternity that he did sign. If he wishes to now challenge that through a DNA, there's probably a process that he can do that. As it stands now, he is judged to be the father.
Well, that's right. I was going to get a copy.
That's right.
Let you see it. In all reality, order Mr. Alexander to pay $500 before the 18th and then $592 a month. You might as well just go ahead and put him in jail. You know, I mean, he not gonna be able to pay that, not gonna pay that. And, you know, I mean, 492 toward child support obligation and additional 100 toward the arrears. How is who calculated the 492? What's that based on? You know, come around. What kind of income do you have to get
That would be based on minimum wage
minimum
with
wage?
4 children.
4 children. Were you challenging all 4 of them?
There was a lot of infidelity in that relationship, so,
Well,
I mean, I'm not saying I challenge all 4 of them, but you know what I mean? Like,
I just wondering what his son.
well, Mr. Hurt, why don't you take this file and once we finish this, you can look at it.
That's
I'll have Mr. Alexander say here, see if there was ever a
Okay,
judgment of paternity.
okay, sure.
Give that to Mr. Hurt. And I'll lay this contempt order. Don't let me forget
That's
it.
fine. Thank you.
Mr. Alexander, you make sure you stay around, okay? Hill versus Haywood.
June 27th, please.
Hill versus Haywood. Okay, what do you want this one here? You gonna reschedule it for June 27th, you say?
Just order for future review, yes.
And then we got Garcia versus Garcia.
This is an order for change of payee. Child support was previously ordered pursuant to the divorce between these parties. We're just asking the court at the petitioner's request to change payee so that it's paid through our office rather than directly to the. Thank you, Judge.
And you're gonna look at that Alexander case and do what? Ms. Hurt, she says there's also two paternity files downstairs. You have somebody bring them up? Yeah. Here's this Garcia over. Okay, we're ready for the one. It's 115 docket. Anderson versus Anderson.
Okay.
Go ahead.
Your Honor, Angie had filed exceptions. My understanding from Megan's email is we were going to discuss the matter of recusal today.
Go ahead.
Judge, we had filed the motion for recusal. Just to be candid with the court, we had talked, amongst the 4 of us at an informal settlement conference, prior to the case really getting underway. And it just kind of all been under the assumption that Your Honor would recuse from the case, was my understanding. Therefore, we just filed a boilerplate recusal motion. It's not based on, the family connection so much as personal knowledge of the facts of the case. Specifically, I would say, one of the big issues in this, Nor ruled that,
Well, I'll start off by telling you that I'm not pleased with Norb's rulings at all, because a lot of things were completely left out. You know, the retirement issue was not addressed, because things that are not addressed doesn't mean that they don't have to be addressed. So I I think there's some validity to that, but go ahead.
Judge, the retirement issue was held in abeyance by the parties, and that was put on the record at Norb's hearing.
I'm just
to be
looking
heard
at what
later.
his findings were.
Sure,
You know.
I understand.
But I don't see how you put a crucial part of division of property in abeyance. I don't understand that unless there's an agreement to waive it or anything. Was there?
There was an agreement to place it in abeyance.
I don't know what that means.
To essentially get our documents together, get with each other, try to figure it out without having a protracted hearing on it.
Well, let's deal. I mean, do you have any specificity about what knowledge I supposedly have about this case?
No, Judge, just, again, just your Honor's relationship with the parties. What I was getting to is, one of the issues is, everybody testified, all Kristen's witnesses testified at the hearing that Mr. Anderson was a good dad, all that. But one of the issues that came up was parenting techniques, parenting styles, amount of time around the children, the different functions and whatnot. My client is under the impression that your Honor would have intimate knowledge of that.
Well, he's wrong about that. You know, I doubt if I know where they live. I'm related to both of them, but not within the consanguinity situations that would have me to recuse myself. I have been at their home where they were maybe on 2 occasions, maybe 2 occasions, 3 occasions. Both of them were there. They both used to go to church where I go to church. She still does. He doesn't. You know, I'm not in regular contact with him. I know nothing about it. I don't know anything about his parenting skills, but I will say that I reviewed what they said and what was in his findings, and both of them said that he was a good parent. So I don't even know whether that'll be an issue as far as the time or the visitation, or if that's, I don't even know whether that's an issue or not. But I do know that there are other issues that need to be cleaned up. And I don't know whether to send it back to the commissioner who didn't clean the issues up and have them cleaned up, or to whether to have them to hear them myself, and I can make a record where you can appeal. That's the great thing about the system that we have to both of y'all is if I'm wrong about something, then you can take it up. I don't have the final decision on anything. The Court of Appeals can decide whether I'm wrong or whether I abuse my discretion or not. Now, what were the exceptions that you filed?
Well, we filed exceptions to the parenting timeshare division. We also filed exceptions to the retirement issue because there were concerns about, we didn't have some of the documents.
What was the other thing?
And then also on the marital residence.
Yeah, I'm interested in the law on the marital residence. Both of you presumed what it was one way or the other, that sort of thing. And I wasn't, there wasn't any case, there wasn't much case law on that. I'm interested in that. I'm interested in the retirement situation. Now, I do know a little bit about teacher retirement and settlements and cases because I experienced that. And the problem that you have in teacher retirement, which is a protected retirement system, they have virtually no value when you compare them to a 401k or that sort of thing. You know, doing a valuation on one of those, I don't know how long Miss Anderson has taught. How long have you taught? 12 years. Well, a teacher retirement at 12 years is virtually has no value. As you're probably aware, because if a person tried to draw on it right now, it wouldn't have any value. And I would assume that he has a 401k or something like that. Is that correct? How much does he have in the 401k? That's what we're talking about. Do what? Yeah. Yeah. See, that's a problem. I mean, that's a valuation problem. And I don't feel comfortable making that valuation because when you get a 305,000 or a 401k, that's what it's worth. You know, it's worth 305,000. And so that's the reason that I'm displeased with the commissioner of letting that thing slide, because it appears to me that that's the major asset, that the major marital asset that the people have. And some of that's probably not attributed. He probably had some of that before they were married. So obviously, anything that he had before they were married would be backed out of evaluation and only be fair to him to do that. I mean, you can't include things he, accumulated before he was married into the marital asset.
And to be candid, Judge, Mr. Gorman did provide me with documentation showing what he had as non-marital, but I never got anything showing what his current 401k value was
So
from the time of
we
marriage.
need to exchange that information. And I would suggest that would be something, and there are expert witnesses out there that will, or you can probably look at case law and see what, teacher retirement is worth. So you have to do evaluation of both of those, and then the rest of it will have to be divided, usually 50-50, on what's left. And I don't know, how many years were y'all married?
So they were married June of 2015.
7 years, so. And you would assume that as the salary elevated over the years, that more of it would be in than out of, if he had, how many years did you work for this company? 11. Did you transfer did you ever work anyplace else that transferred money over into that from another 401k? They do that sometimes, if you work, because that's. Yeah, that's the great thing about 401ks or these things is they're fungible and you can take them over sometimes. So y'all need to work that particular situation out. And then if you can't agree on that amount, I can make a finding on that. The other thing is, I guess we can look at the factual, do you agree to the factual situation on the marital residence about when it was purchased, and what's your argument on that?
Judge, we agree that it was purchased a year prior to the marriage.
Yeah.
But my client took out a loan and made the payments on those loans for the down payment. And then we have I guess for case law, there's a 2013 case, Smith versus Smith. It's 2011 CA 2306 that basically talks about source of funding rules when you're looking at, was it a joint venture between the two of them while they were cohabitating? And that's what that case says, that if you can establish that. So he's got some non-equitable or non-marital claims, and so does she, because of that aspect. And then they didn't pay.
Did Mr. Anderson put any money toward the purchase price?
Not on the down payment, he didn't. He was he was putting money toward the mortgage payments during that year before they got married. And that's the other issue, is there's a mortgage, so it wasn't like it was an asset that there was a lot of equity built up, because the house was purchased for $200,000. As of August last year, there was still over $152,000 owed against the house.
That's what happens those first years. They get you with the interest,
Yes, so, I don't know how you can determine that's a fully non-marital asset when clearly she has marital claims in the equity that's built during the marriage. The fact that she made payments on the down payment and contributed that, and Mr. Anderson didn't for the down payment.
Well, I'll admit up front that I don't know what the law is on that, because we don't handle that very often, because we have very few people that have a house that they bought immediately before marriage. I know we're not a marital property state, that sort of thing. So are you convinced you're right about this?
Yes, Your Honor.
Yeah. Well, I want both of you to brief it in detail let's see if we can agree on the facts that you brief it on. Okay. Now, we agree on what the purchase price of the house was what?
200,000.
200,000. Okay. Now, where did the down payment come from?
My client took out two separate loans.
How much were they?
One was for a little over 10,000, one was over 17,000.
Okay, so that's $27,000
Mhm.
down payment. You agree with that? Mr. Garman, you agree with that?
Judge, no, I don't think that's what the proof stated. I will just say, when we had the hearing, there were no documents presented.
Well, I know that. That's a problem, okay? And I wouldn't accept that. If I'd been hearing it, I wouldn't accept no documents are presented. And the fact that they weren't presented is not going to be a gotcha thing to me. We're going to present the documents, and we're going to get everything on the record, so either side that doesn't like what I do can appeal it, and there'll be a full record there. Now, I don't know what happened in this hearing, but I'm not pleased with the fact that these people have been hung out there to wait all this extra time without findings made on crucial things. Now, I don't know whether it's the lawyer's fault or the commissioner's fault, but we're gonna make sure that nobody has any fault, because we're gonna get this straightened out. We're gonna go right down through the middle and go by the law and the facts of this situation. So I don't really care what happened at the hearing, okay? You know, if it wasn't there, just because it wasn't there doesn't mean it's not there. So I want us to establish, she says 27,000, okay? What you say, where did the down payment come from, does your client say?
Judge, honestly, I can't remember.
Well, you shouldn't have to have him do it right now. You find out from him where his explanation of the 27,000, if he had any down payment made. So you got a $200,000 house, somebody made a $27,000 payment on it. Now, were they cohabitating during this time period?
Judge, we disagreed that the down payment was 27.
I'm saying that's what they say.
Right.
I'm giving you time to come up with factual documents on what you say. I'm not taking anybody's, what was said, this said, nothing like that. I want to look at documents, and what proof you had. She says she made 27,000. If he disputes that, where the 27 or how much he made, you're going to have an opportunity to get that in line. You see what I'm saying? I'm not taking anything, because I don't think this was delved into appropriately at the testimony. So we're going to open it back up as far as the down payments is concerned. Okay. And then he can say where he said now, okay, so you got, let's say for purpose of structure, there's $200,000. We all agree that $27,000 down payment was made on the house, which where that came from.
And for candor, Judge, some of that may have been closing costs, but
Well,
she took out the two loans that were added
Well,
to
you
the
need
payment.
you need to prove where that $27,000 went. You need to track it through and what it was for, okay? And closing costs, in my opinion, were they cohabit,
They were cohabitating,
So
yes.
so what you got is you've got a couple cohabitating, and they buy a $200,000 house, and it's an allegation that she takes out a $27,000 loan on the thing. You're going to dispute that, okay? But let's say for the purpose of this, to set it out there, she does, and so there's 63,000 left to pay, and they start paying mortgage payments on that, and so he makes the payments for a year. If she did make the $27,000 payments, it would appear to me that he would be entitled to an offset for those mortgage payments that he made for that year. You follow what I'm saying?
Yes, Your Honor.
Okay, so that's the sort of information I need. And then once we get to that point, then they get married. Now, I can't believe that the law in this state that you got two people cohabitating and one of them makes a down payment of 27,000 or whatever, the other makes a payment, they cohabitate and get married a year later, and she gets nothing out of it. I don't believe that's the law. If it is, I want to be presented.
Judge, it wasn't ruled that she got nothing. She got half of the equity. She got $24,000, but she got half the difference between 200 and 152.
But then we're also disputing what the commissioner determined is the equity, because we've got an appraisal on the
Well,
house that's much greater.
Is it worth 200 down? What's it worth now?
Judge, I don't know. We had a final hearing. It wasn't
See,
presented.
the problem is nobody brought up any of this stuff. I mean, you got a hearing that there's I just don't think there's significant information involved for me to even make a determination on it. And you don't have any final hearings in front of a commissioner. You have hearings in front of a commissioner and recommendations, and if either side brings up issues, then you open the whole thing back up, okay? So I really, up to this juncture, haven't seen that much. From what I've seen, I don't see there's a lot of reopening the custody sort of things or the visitation at the time. There might not be any opening of that up because everybody had their chance to give all the facts on that stuff, and whether they decided to disparage each other or not disparage each other, I'm commending both of them for not, if they didn't disparage each other, that's commendable.
Rather clean here.
That's commendable to both of them. Okay, but now when we get these other situations, I'm not going to let the fact that this wasn't discussed or that wasn't discussed or appraisal wasn't there. Did you present the appraisal at the hearing?
We did not, Judge, because we didn't get it till after the fact.
Yeah. Well, I'm going to open the issue up on the retirement plan and on the house. Okay. But I'm going to give everybody a chance to take a big bite out of those apples as you want to. Okay. to make sure we do the right thing. So we create a record that can go up. Now, let me ask you something else. Do y'all wanna, bifurcate this thing and get them divorced today?
Yes, Your Honor.
Yes.
So everybody agrees to that. That's a good thing. We'll cut this thing off today. Y'all submit me an agreed order on divorce and hold in abeyance any other issues that might exist as far as property or, and I have an obligation to review the record on the visitation stuff. I haven't seen anything that make me indicate that it's any different. That I want anything different on any visitation or time sharing. I don't know anything just from what I've read in the situation, but what kind of time frame are we gonna have to do this information on these properties?
You mean as far as like a briefing schedule, Judge?
Yeah, number one, we got it. If you want, what does your appraisal say the property's worth?
280,000.
Okay, well, why don't you provide them a copy of that? And then if you want to get a legitimate appraisal that takes an opposite situation or an opposing view to that, I'll give you time to get an appraisal done. If you think that one, who did your appraisal?
Bear with me just a minute, Judge. It's Wilson Appraisals out of Tompkinsville.
Yeah.
I'll give you a copy of this.
If you received a copy of that
No,
yet?
So I just told him
Okay.
I could give
Give
him
him
a copy of it.
today of the appraisal, and if you take issue with the appraisal or give you some time to get some other appraisal done to see if you want to take issue. You might not want to take issue, but if you want to, I'll give you 30 days to get another appraisal done and see if you want to take issue with that, okay? Now, as far as, there's really nothing else to decide on what you want to brief between now and then. Let's just assume that we have some other valuation other than 200,000. I want to find out with the fact situation where people are cohabitating with each other. One of them makes a down payment, which is still disputed, and the other one makes payments for a year. What they're entitled to as far as a division of the property. And you think that you think that she would be entitled to a percentage of increase in value from the date they married to they divorced? What do you think she would be entitled
Not
to?
pursuant to the case law.
Well, I'm asking you, I know you think that's what the case law says, and I'm asking you what your position is on what she would be entitled to.
Judge, I think the down payment again, that could be an issue. I don't think she would be entitled to any increase in equity in non-marital property based on the facts. General market conditions is what the case law says.
Well, what do you mean general market conditions?
That's what the case
Okay,
law
well, I
says.
know, I don't know. It's not a whole sentence.
When there's
Let me ask you this. Let me ask you a question you give me a whole sentence answer to, okay? Let's say they get married on December the 1st of whatever year it is. Now, is she entitled to the increase in value? You value the property on the day they were married, and then she would be entitled to a percentage on the increase during their marriage. Is that what you're saying? You understand that question?
No, Your Honor.
Tell me give me a factual situation of what you think she's entitled to. You said she got 24,000. What does that 24,000 represent? How was that?
24,000 represents half of the equity between the time that the parties purchased the house and the time that the parties got divorced. Or, well, they're not technically divorced, but now, basically, at least as of the date of the hearing. So that there's 152 owing on the mortgage. There's 200 paid on the house, so 24 splitting the baby half and half.
Well, what if the thing's worth 280,000?
Well, Judge, that was my point. The case law differentiates between a house going up in value based on general market conditions versus a house going up based on improvements that the parties have made. Speaking of, this didn't come up in the hearing because there was no appraisal and no issue on the valuation. But his testimony will be that there's been very minimal improvements made to the house. So she would only be entitled to half of the equity from those improvements, which would be minimal.
But then there's the presumption that the house is automatically his non-marital, and I don't know how you get there, Judge. I
We
mean,
can brief it. I think the case law is clear on that.
Yeah, well, I look forward to being educated on it both ways. But it would appear to me, that you have a couple that's already cohabitating. I don't know why anybody would agree to put the title in one of the other of them. I don't know why that happened, but I can't go back. But you got people cohabitating. One party makes a 27 or whatever down payment on it. The other party ameliorates that by making payments for a year. They get married in the same house. They're living there that they bought together. And you're saying that what she would be entitled to, the $24,000, comes from the 200,000 minus what the mortgage is today.
That's correct, Judge.
And so she,
Half of that amount, yes. He obviously gets one half and she would get one half.
yeah. Well, I can't imagine that's the law, but if it is, it is. You brief, both of you brief it. You understand what you're briefing and you understand what you're briefing?
I believe so.
Okay, so I do think it would be helpful, just for the record purposes, for you to introduce your appraisal into the record. You have it with you today?
I do, Judge.
Okay.
If we could get Mr. Garman a copy as well, I only brought one copy
Well,
today.
we got a copy machine here.
She can
Sounds
email
great.
it to me. That's fine.
Well,
I don't
well,
care
you
while
go
we're
ahead and
here.
present it file it today, and then we can provide you a copy today, the old fashioned way, the clerk over here, okay? Then you're given, you can give 30 days to either accept that appraisal. And the appraisal might not be an issue if you're right on the law. It might not be an issue, but at least you need to know what the appraisal is as you plan your strategy. Is that fair?
Yeah.
Okay. So we got, and then the issue has got to be, there needs to be, you say you've already been provided what he's put into the 401k or whatever it is?
Not his current 401k. He kept what was non-marital separate in a separate type of 401k or transferred it. They provided those documents, but I don't have any idea what his 401k is currently that he has with his employer and what he's had since they got married.
Okay, well, you need to provide
We'll
that.
provide those documents. And Judge, I'll try to get an amount that had in it at the time of the marriage also for an offset or not.
Well, yeah, you'll need to have a complete list of
Yeah,
everything
we'll
as long
try
as
to
he
get
was
all
that
that.
company. And were you working with that company when y'all married? Okay, so it's,
The company that would be used has changed hands.
yeah,
But their records with the current company only go back so far. They
Yeah.
go back far enough.
well, your 401k should be the
401k
same.
would have that.
It should be, they shouldn't have changed the title of the 401k.
We'll dig in and get one.
It's the same amount of money, but
Yeah, I got you. Okay, well, just, what you're looking for is you
Yes,
go to the date of marriage forward on the 401k contributions. And that'll get how much is in that. And then I would assume that since this issue comes up so frequently, that the teacher retirement system will have a brochure or something on evaluation of.
I have a formula of how they break it down with the number of years and the percentages that I can provide.
Yeah,
Mr.
and
Garman as
have you
well.
already looked at that?
Yes.
What is the value of
I mean, as of right now, she has 58,000 in her account, but then, that's what she's paid in over the course of
yeah,
years.
but
But that's not what the value, I haven't done the calculation itself to see the value, but I have the formula that you need to
of
do.
course, you can't take it out. The
No.
problem is, and that's, that when you value something at any particular time, is what it's worth. So y'all need to provide him with the calculation that you're going to use to try to value it. It wouldn't hurt to find an expert. If there are any, I'm sure there are people that are
There's a
experts.
reason why I didn't go into accounting, so I think, we probably do need
Yeah,
to have
okay, so
somebody.
so you value what hers is, and then you value what his is, and then you divide the difference. And it stops today. Nothing else is added after today, because they're divorced. Will be signed if y'all get me the thing today, okay? Okay, now, are there any other questions? Are there any other issues beside the exceptions that you filed? Do those handle the 3 exceptions, Ms. Capps, that you filed?
Yes, Judge.
Okay, you have it.
And then we also were asking about child support. I know that was motions we filed early on. There was a temporary order that was in place to offset monthly expenses. So we still want to preserve that issue that child support needs to be addressed.
Well, she's gonna be, it would appear to me that she's gonna be out of the premises. You know. She not, are you staying at the premises any now? You are, when you have the children, you're staying there? Well, that poses a separate issue.
Judge, that was gonna be,
You
that's
know.
what I was gonna bring up with regard to that, and also if your honor's only considering the financial part of it, he would certainly like to start his timeshare now. He's been at minimal time with these kids for 8 or 9 months since the temporary orders was in place.
Well, I'm going to consider all of it, you know, but I say that from what I know now, the limited knowledge I have now, you know, I don't, she's filed exceptions to it. How much is he getting now?
Just 24 hour period, maybe 2 weeks. Some of the other days are 4:30 in the afternoon, so I think come back. So all in all, you start, I have them.
Let him get behind the microphone.
Sorry.
I'm having a hard time hearing.
So if you start this past week, I got them Wednesday, because we done agreements to swap some days because of one night in which I bowled. We swapped those and one just traded today. I got them Wednesday, last night, till this morning. 4:30 till this morning when I would go back to work. I won't get them again until next Monday at 4:30 until Tuesday morning when I take them back to work. I wouldn't get them again until that following Friday afternoon. I'd have them Friday night. I'd have them for a 24-hour period Saturday, Sunday morning until 9 a.m. She gets them to take them to church, brings them back at 1. I have them from 1 to 7.
I'm having a hard time following this. Could you,
It's 1 day a week and every other week.
one day a week and every other? Okay. 1 day a week and every.
And anytime that he
Yeah,
ever.
okay. Well, why don't y'all go back and see if you can work on anything until we make this larger decision, okay? See if you can work on, how many days a week do you work?
Put them on call,
Yeah,
whatever they.
5, okay. Do you work days or nights? Days, okay. You work days, of course, okay. We all go back there and talk for a second, see, until, if you can, you know, as far as the visitation is concerned, I'm inclined, I want to get this whole thing over with quick. You know, and have y'all already divided the personal property?
Well, I mean, we've made exchange list of what each one was gonna
Well,
get.
y'all
They've
agree
still
on
left
the
it in
personal
house.
property?
Yeah, there's an agreement. It's
You say no?
kind of convoluted, but there's an agreement.
Yeah. Well, let's go ahead and work on the personal property list. Get the information about the retirement. Get the information about the valuation of the house. And then I'll make some modification. Once you get those things, I won't wait another month. If you can't make an agreement today on timeshare, if you can't make agreement on that day, then we'll just do all of it at once, okay? I'm wanting to do all of it at once, and that way you can take it up and appeal it. And I'll make a ruling here that there's nothing been presented to me, nor do I have anything on my heart or mind that would make me recuse myself in this situation. And it's the only thing I can do. People accept or not accept it. You just see the results and everybody can determine, I guess, whether they get what they want, whether I was right in recusing or not recusing. So y'all get to work on that. And if you can't reach any agreement on the timeshare stuff, then we need to advance this other stuff up and let me do one final judgment on it, okay?
Judge, one other issue that I talked to Mr. Garment about as well that we didn't really address, but it's not addressed in the DRC findings either, is, of course, tax time is coming up pretty soon. There's 2 different ways the parties can file taxes. They can either split claiming the deduction for interest on the mortgage and each claim one child, or she'll take both children and he takes all the mortgage deductions. So I just wanted
You
to see
know,
if we could
I've
clarify
always
that.
kind of wondered about this, and I know people don't like to continue to be connected financially, but I've always wondered why people don't don't calculate the tax situation both ways and take which one's more advantageous. For example, there's earned income credits and things like that. I don't know whether either one of them would be entitled. They might make more money than you get in earned income credit. I don't know. And then there are deductions. For example, if you got someone in a higher tax bracket than the other one, it would make advantage for them to take it deductions. If it doesn't apply, if it doesn't do something with the earned income credits, you know what I mean? So I think these are both well-educated and intelligent people who know the value of a dollar. They need to calculate which one is the best way and split the difference. You know, in other words, if it's better for her to take them and they get more money that way, then she can give him some of the money. And if it's better for him to claim both of them for some purpose in a particular year, he can do that and give her some of the money. Does that make sense? Is that?
It makes sense to me as long as me and Angie aren't responsible for that.
Exactly.
For doing it.
And I did-
As long as they talk to their accountants instead of us.
I did have my client talk to someone that would be prepared for taxes and to see which would be more advantageous. But because of the change in the tax rules where they've technically not been together or living together for the last 6 months, those rules apply.
I don't know that
So-
they haven't been living together. They've been living in the same house. I don't know. Well, if it's your tax advantage, I think I might have been doing that. So I don't know. I'm not to say that. That's somebody else. Okay, if y'all can work through that. And then, if you can't reach an agreement on this timeshare stuff today, I understand that, and we'll just do it all at once. Okay? I would encourage people to continue to try to work toward more time, you know, because at some juncture as they get, especially as they get older, you know, there's going to be more time. There needs to be more time, you know.
Judge, I just have one question you said we got 30 days to review the appraisal, rebut it if we want to. What about as far as briefing the remainder of the issues? Does that also need to be done within 30 days?
Yeah, I mean, yeah, you can brief it within 30 days. The fact of this money, I mean, the fact of how much money we're talking about shouldn't change what the law is.
Right.
You know, so you can go ahead and brief it but you need 30 days or 15 days to brief what the law is. Or you can do all of it in 30 days if you want to. Both of you simultaneously brief your situation in 30 days, and I'll give each one of you 10 days for rebuttals. Does that sound fair?
That sounds great.
Okay. Thank y'all very much.
Thank you.
Thank you, Ron.
Yeah. Okay, now we have Carver versus Carver. What do you have?
May I recall
Yeah,
the
come on.
Alexander case?
Yeah, let us recall the Alexander case first.
I'll be very brief.
Yeah.
If
What-
it can be,
Mr.
something I need to back and forth with it.
Okay, Mr. Alexander, you want to come up here?
Just responding to the court's earlier
Okay, wait a
question.
minute. Okay, can you hear Mr. Alexander? You hear what's going on? Okay, go ahead.
Judge, there were, the children that were referenced earlier, that are, dealt with in this case, and I'm gonna use the initials because I think 3 of them are still juveniles.
Yeah.
There were 2 juvenile cases, 11J00059, in which Mr. Alexander signed an agreed order acknowledging paternity. That order was entered on January 4th, 2012. That was for AA and RA. It's a separate juvenile action, 5J00012, where Mr. Alexander signed an agreed order acknowledging paternity for MALA, and that order was entered by the court August 16th.
So all that he has acknowledgements of paternity on all the children involved.
And I've just presented him and shown him those. And I've also
Yeah.
explained to him that if he has questions about wanting a DNA test, he's welcome at my office.
Yeah.
But I presented and showed him those
Well,
copies.
these orders will be in place until they're overturned because you sign these acknowledgements. It doesn't mean that you can't go back and challenge one or more of them. But now, here's the deal. I'm gonna sign this order here that he's got, but I'm signing an order that I don't think you can comply with. I don't know why but that's what the law is. You know, as far as the 500 by so-and-so and make the other 500. So I suggest that, are you drawing a disability of any kind? Okay, so you need to get you a job and go over and work with the county attorney's office to see if you'll do a wage assignment or something that would help them let you ease into this thing.
And if he will come see me, I will work with Mr. Alexander.
Right now, I have, My health is failing.
Well, you don't have a disability situation in, so until you get some kind of disability situation in, you're gonna have to pay this. And I'll get you a copy of the order. You go over and work with it. Thank you very much.
All right.
Okay.
Thank you, Judge. That's all.
Okay, LaCosta Smith Carver versus Brett Carver.
Your Honor, before we get started,
You need to get behind the microphone and speak up a little
Your
bit.
Honor, before we get started, Mr. Carver needs to go pick up the party's son in Albany from school by 2:30. And so I'm prepared to waive his presence, but if there's any need for him to say anything today, it ought to be, I don't think there would be, but that.
Well, let's see what they have to say. Okay, you have a motion for contempt.
I do, Your Honor, and that's not the first motion in time. I'm happy to address that when the court would like me to.
You address whatever you got in order you want.
Okay. I'll say this, Your Honor. Your Honor, back to break. Can he be released?
I don't know yet. I don't know whether his testimony is gonna be
Well,
required.
I thought you were going to ask Mr. Davenport if he needed him.
I don't
Well,
intend to elicit testimony from Mr. Carver myself. Now, he's got a motion for exceptions on, and he needs to speak to that motion himself.
Well, I think that one was filed first, so. But,
Go ahead. You need your client? What do you want to say here?
Your Honor, the party's priority is their son. Brett would like to be released to go get him.
Okay. There's nobody that can pick the child up?
Everybody else is Ms. Willis's funeral.
Okay, what do you want to call? You want to call him for what purpose?
No, I don't need to call Brett. That's what I'm
Okay,
saying.
what is your motion?
Exceptions.
Okay, what exception? Just flip down through them real
Well,
quick.
Your Honor, the exception is the commissioner has set forth a computation for the party's income based on Brett having
Oh, I remember that now.
$185,000 year income, which is bewildering. And if he'll set forth his findings on that, maybe it's justified, but it's just, he says it's based on testimony. He's got no job, not regular. So-
Well, he lost a job
Right.
that he had because of criminal allegations, correct?
Correct.
Okay, now okay,
Yeah, Judge.
now what's your position?
my
Let's say someone has a big job and there's a criminal allegation against them and they lose the job. They no longer
403.
have the job, okay?
KRS 403-212, specifically sub B, I believe it is, defines for Your Honor income in the child support context and specifically says income includes that income which one is expected to earn if they are voluntarily underemployed or unemployed. And this is a textbook underemployment situation. On top of that, Your Honor,
Why is it a textbook underemployment?
because his earning potential is more than what he's currently earning as exhibited by years of earning potential that was presented to Commissioner Song. What Mr. Cross isn't telling the court is this was an evidentiary hearing that was conducted in November. It was originally set for September. It was continued with the agreement that certain discovery would be provided, which I'll speak to for the third time about that again in a moment. But when that wasn't provided, I re-noticed the motion for November. The commissioner heard proof. Mr. Carver presented no proof of his income. He simply said, I don't have any income. We know that's not true. His tax returns that were submitted in evidence at that hearing shows that he has at least 4 streams of income. He had the job that Your Honor has referred to that he's been relieved of. And I'll submit to you, that was the largest portion of his income. He also had farming income that was submitted. He also has directorship income. The most recent tax returns that we provided show that the director income was in excess of $25,000 a year. His farming income was producing receipts in excess of $250,000.
What was the net on farming?
Well, the farming, the Schedule F would show a loss. Your Honor would anticipate that. Every farmer I've ever seen shows a loss. But luckily, 403-212 guides us that not all those expenses, although
I
legitimate.
understand that.
Yeah, so for instance, he had $80,000 in accelerated depreciation. Under 212, he gets to claim none of that on child support, zero.
Yeah.
Only standard depreciation.
Yeah.
So when Mr. Cross says, well, there was no proof of this, there was a plethora of proof. Mr. Carver's problem was he didn't offer proof. And when the commissioner set deadlines to file proposals, we did that in December. Guess who didn't do that? Mr. Carver didn't do that. And now he's filed exceptions, and his relief, if you look at the exceptions, is he wants the opportunity to present income information and a calculation. He ignored the commissioner that opportunity twice. This case has been pending now for 10 months. Mrs. Carver has received zero in child support for Mr. Carver. Zero. And I apologize for what is probably coming across as indignancy on my part. But I'm pushing a wagon up a hill and somebody's pushing against the wagon down the hill. And I've been doing that for 10 months. And, I feel like every grace that's been extended Mr. Carver in this case has been ignored. And who's paying the price here is Mrs. Carver and their child.
Why is your client not paying any child support?
Your Honor, he's prepared to start this.
Well, no, I'm not asking what he's prepared. They all come prepared after they get up here and call it
Right,
in.
right.
I'm asking why he hadn't paid any up to this.
Well, Your Honor, the recommendation was here the 14th day of February. He had no idea what to pay. He owes from September, whatever amount this court determines. He's prepared to start paying immediately. We've had that discussion and that's going to happen because he doesn't need to get farther behind.
Well, let me
He's got-
ask you one question.
Yes.
Let me ask you a question. Counsel, I want you to listen to this here. Let's say that it's true, the allegations in the criminal complaint. Let's say they're true. How much money do they claim? And I'm not saying it's true that he absconded from.
The indictment refers to $212,000.
Yeah, okay. Now, if he had $212,000 of additional income that he didn't report, then that could affect the amount of child support that he was entitled to because,
Your Honor, if is the longest word.
well, it is,
And,
it is,
and
but
that
I'm,
is simply not correct.
well, I'm just saying if that, just putting out there is a worst case scenario for the
Yes,
client. You
understood.
see what I'm saying? I'm not saying he did take a dime. I don't know what he did because I intentionally don't know anything about these cases. As a matter of fact, I don't even think the indictment had an amount in it, as I remember.
The amounts this year are $212,000.
Yeah, okay. Okay, you can go unless you want to call him for anything else. You don't need him for anything else.
I do not.
Okay, now, do you have anything else that you like? Then I'll get back to you.
Child support issue, I did not, Your Honor. That's my piece on that. We had 2 hearing dates. We continued one at Mr. Carver's request so he could provide information. He never did. So we had the hearing. He didn't provide information.
So I'm gonna rule with you on the child support matter and you go ahead and proceed as if there are change, you can file a motion for change of circumstance.
We can do that.
The only thing that I think that I do need to request is that order should be retroactive to August when the motion was filed.
Absolutely,
I agree with that. I could stipulate that.
absolutely. So, and then if he can come in and do a drastic change circumstance, we'll address that when it comes,
Yes,
okay?
Your Honor.
Now, if there's anything else you got,
I have a motion for contempt I do need to address when. Your
okay,
Honor wants
address
to
it
hear.
quickly and then I'll let you.
Thanks.
Judge, the motion was filed when, you may recall, we were here January 24th for Your Honor. There was an order that was entered in September, said I'd receive discovery in 20 days. I was here in January.
What are
still-
you entitled to now? What
Well-
don't you have?
I don't have verified responses.
Okay.
I don't have the most recent attachments to the preliminary disclosures that were filed 2
Okay,
weeks
you
late.
need to you need to make a list here. Y'all making a list?
No, we don't have to, Your Honor. He's done it.
I do not have verified responses. The interrogatory answers aren't even signed by Mr. Carver, much less verified. And Rule 33.1 sub 2 says that they are to be filed under oath, signed under oath by the party.
If they've not been oversight or aren't coming in or check, we'll have to do that to the next player, so we'll get that too.
Okay, now. Okay, what else you need?
I need the attachments that should have been filed with the disclosures. Mr. Cross says that they were part of the discovery. I got the
What
discovery.
attachment are you talking about?
So he's required to provide 3 months of income statements, 3 months of bank statements. And the discovery answers give, bank statements up to, I believe, October of 2023. I don't have anything that would be timely since that time. That's one thing, with the disclosures. And then secondly, Mr. Carver was also ordered to pay $750 in sanctions within 20 days. Along with these answers, he didn't do that either. So, although the preliminary disclosures were 2 weeks late, if I can get verified statement, interrogatory answers, if I can get the 3 months of the bank statements and the income statements that he should have provided, and if I could get the $750 that was ordered here in January, I believe, without going further through those various attachments, it would seem that he would be in compliance.
Okay, did you get that, Mr. Cross?
I have, but are you ready for me?
Yeah.
Mayor? Thank you, Ron. First of all, Your Honor, I do want to correct one of our filing with the court. Our response to the petitioner's motion for contempt reflected that the counsel for the respondent had denied knowledge of a Mr. Vincent. And to refresh, I'm sure you read it, we mailed a box of discovery out on February 10th. It disappeared for a period of time. We called, and when we got this motion that said nothing had been filed, of course, we got on the phone to his office. Mr. Davenport was not present. And we spoke to Ms. Harwood, but we also spoke to someone else who acknowledged that they were new, but they had no knowledge of this Mr. Vincent who had supposedly signed for this package. Mr. Davenport's, there was no offense meant to be given, but Mr. Davenport is offended that I have asserted that he denied it, and he did not. So I want to correct that with the court. Okay, it was his office. We're all responsible for everything that happens in our office, but it was someone within his office that said they didn't know who this fellow was. He was a former employee. Post office is, I don't know what happened, but we mailed
Okay,
this.
let's cut to the chase.
Well, I know, but I just want you to
Well,
understand that everything
It
was
won't
sent.
offend me that somebody didn't get or whatever. I want to get it done now.
Well,
Okay.
we.
Okay, now let's give me a list of what you owe him and see if he agrees to that so we can get it on the record.
Your Honor, the first thing he wants is $750.
Yeah.
The second thing they want is child support to be paid, of course, and we'll be filing a motion to modify. The third thing that he wants is verification regarding the discovery and regarding the other aspects
Okay,
of it.
can you do the verification on the?
Yeah.
On the discovery? Okay,
Yes.
go ahead.
Now, as far
What's
as-
the other thing?
As far as what.
What do you owe him? What discovery does he owe you if he does a
He
verification?
doesn't know. He hasn't seen it yet. It was picked up at the court, at the post office by his office staff. He doesn't know what we've sent and what we haven't.
That's not entirely true. I got the discovery responses this afternoon, but I did get the preliminary disclosures last week. And that is what is missing, the 3 months income and bank statements.
So you can get him 3 months income and bank
And
statements.
these are the most recent 3 months, Mr. Davenport.
That is what the preliminary disclosure requires.
Thank you.
Just the most recent 3 months.
Correct, Your Honor.
Sorry, 3 months back.
Correct.
Okay, that's what you have to have.
That'll be
You're
fine.
gonna make sure that the verification is signed.
Yes.
You have a ruling on the child support and you owe him $750.
Yes.
Does that take care of everything?
It does, Your Honor.
Okay,
Temporarily.
draft an order.
Thank you.
I will.
Do what?
For the time being, Mr. Davenport, if you just send it over for have seen, I'd appreciate it. Thank you, sir.
Okay, thank y'all very much.
Thank you, Judge. Have a good afternoon.
Okay. Okay, do we have any, is there any other matter on the docket? Not? We have a confidential matter, I guess. Is it time for the confidential matter?
There's an EPO.
As the EPO? What is that here?
It's the-
Okay, DVO docket. Christie Nicole Lee versus Jared Wayne Stewart has not been served. Remain enforced, okay? The confidential docket starts at 2. So it's time for the confidential docket. If you're involved in 23 AD 000